Judges, it's Maytha here. I would like to begin by reading out a statement which in return I will ask you and counsel to confirm is correct. I hope that is okay.
Yes, please.
The appeal hearing is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the appeal bench instructions. Will the judges and parties representative please confirm that the situation is as I have stated?
I confirm.
Confirm, sir.
Confirm.
Mr. Montague, you confirm? So all the five of us confirm. Yes, we are confirmed.
Thank you very much. We are here for a hearing in the matter of CA-001-2020 before Chief Justice Zaki Azmi, Justice Roger Giles, and His Excellency Justice Ali Al-Madhani. The appellant is represented by Banks Legal Consultancy. Lead counsel is Roger Bowden. The respondent is represented by Taylor Wessing LLP. Lead counsel is Tom Montague Smith QC.
Yes, great. So, Mr. Bowden, would you like to start?
Yes. Good morning, sir. Do you have the case lines system available to you and on your screens? And if so, yes, could you open that and go to follow presentation, please? On the top screen.
Follow presentation. How do I get to that?
Present.
How do I get
Go on the top bar, sir. Home, find, view, present. If you click present and then follow presenter, I've just started a presentation, and you should see me, sir, as the person to follow.
Mm-hmm. Present. Yes, present. You want to see present? Did you say present?
Yes. If you click on present, sir, and then
I've got present. I got present here.
Yeah, and then follow. Well, I'm hoping my name will be there, sir. I can see Justice Madhani's come in, Mr. Baldwin's come in, Mr. Montague's come in.
Auto fellow present. No, not fellow presenter. Yes. You're not a fellow presenter.
I am the presenter, sir. At this point.
Okay. Okay. But I don't see your picture. I don't see you on the screen.
But you're engaged, sir.
Okay.
I think we're running.
On the screen is just a page, first page of your skeletal submission. Yeah. Okay, that's great.
Yes.
Before we start, how long do you think you take, Mr. Bowden?
I'm thinking. I'm really hoping, sir, to get this done in 2 hours.
Okay.
That's my plan.
Yeah, and how do you plan to do it? In a sense that what do you want to do first?
Yes,
and do you want to follow the skeleton argument, or do you want
precisely, sir? The B15, the skeleton argument from 3 weeks ago, sir, is the primary document, and I'll be going through that. And we have set up a number of hyperlinks, and where necessary, I'll jump to that. I have working notes, which I'll run to. Excuse me, Justice Giles, do you see the case lines?
No, and it's not working for me, so I'll just have to listen to what you say and give me appropriate references to the e-bundle when you get to them, please.
Yes, sir. Shall we persist and try and find it, or you? I take it you've done everything. You know exactly what you're doing, but it's just not working.
You proceed.
Thank you. Well, in that case, sir, I would like to go to just quickly start at bundle B7, and if you're following the presentation, I'll go straight there. And I'm just going to go to paragraph 3 of B7, because these are the orders. So paragraph 3 of B7 are the orders that we seek. These were the orders sought at trial, and they remain the orders that we seek now, although there's a final wash-up order involving the Registrar of Companies, which we'll come to at the end. But so what's sought now is exactly the same as what was sought in the beginning. And then if I can quickly move down to paragraph 7 of the same document, that is the procedural history. And it simply sets out the date of the filing, the two previous Court of Appeal hearings, orders from earlier orders from Justice Mahari, and then leading up to the hearing on the 28th and 29th of May 2019. So if I now can start my submissions proper, and that takes us to document B15, which is the supplementary skeleton dated the 18th of August. And if you see that document says, down the left-hand side are some, I'll call it purple, magenta maybe, and these are hyperlinks. And the ones here dated HB 249 through to 266 are internal documents, and they help you navigate around this document itself. If you see up in the top right-hand corner there, the number B248. So those first numbers next to the table of contents, on the left-hand side of the table of contents in a magenta color, are the hyperlinks within the document. And it seems to be a feature of case lines that every time you go out of a document and back in, it always puts you in back at the top. Doesn't matter where you were in the document. And so this is how we will navigate. So if I might move down to the very first paragraph, the respondent, a little uncharitably, has described the appellant's notice of appeal as repetitive and unfocused. What we say about that document, sir, and that's dated December 2019, is that it is true. However, we accept that what that document does, and this is the notice of appeal, points of appeal, sir, it attempts to follow the structure of the judgment, which I confess is not easy. And so my learned friend, Mr. Tom Montague-Smith, QC, has approached it, as we did at trial actually, on the basis of contract, registration, equity, estoppel. And so I have reverted to that format as well, as being a better format. So it doesn't follow exactly the structure of the judgment, but it does follow the structure of the case. So if we might start there. Now I'm at paragraph 3 of the skeleton, we'll call it the supplementary skeleton, says, and the claimant's primary evidence was contained in the witness statement of Naran al-Maklafi, who was a staff solicitor with Hamdan al-Shamsi. And that evidence, says, you'll see it on the left-hand side, it is D1 and D2. And the hyperlinks, most of the hyperlinks in this document go firstly to the first witness statement of Naran al-Maklafi, and secondly, then that document also has its own set of hyperlinks which go to the exhibits. For the most part, all we need to do is look at the witness statement itself, because it has copy typed everything out of the exhibits and put it into the witness statement. The witness statement is 54 pages long. It is an A to Z of everything that has happened in this case, apart from late documents. And paragraph 4 of my supplementary submission now says the only other relevant documents are those that Emirates supplied late or came about during the hearing process, and so particularly I'm talking there about the evidence of the Registrar of Real Property, short form RAW, whose evidence Emirates, whose evidence is that it relied on Emirates' advice in removing the lease from the registrar, and also deals with Emirates' subsequent admission that the registration of the lease was a formal record of a lease being entered in the DIFC. So, just to interpolate there, Your Honours, at the end of the Court of Appeal hearing at now the end of 2017, none of this was clear. What exactly had happened to the lease. We knew at that stage that there had been a registration, or a purported registration of the lease on the 28th of May 2012, but nobody knew how it had come off the register. And what I say now is that it's subsequently become clear what happened to this lease. So then, sir, we then discussed very briefly The overview, Vegie Bar is I'm at paragraph 5 of the supplementary submission. Vegie Bar is a DIFC registered company. 2010 signed a 10-year lease for 2 units in the commercial part of Limestone House. And just again, just for a little bit of background, Limestone House is of course where the Ritz-Carlton is. If your honours are familiar with the Belge Bar, the Belgian beer bar that is outside the outside bar of the DIFC Ritz-Carlton, if you go out into that bar and you look south towards Business Bay, it's 2 stories high, I believe, the walls around that bar. If you're looking directly south, these units and this proposed restaurant was immediately at the top of that wall on the podium level. And now, of course, the podium level has recently been developed, and there's a number of restaurants, etc., which are opening up on that level. That's the boulevard walkway. So there's now a mall underneath and a walkway on top. I hope that's helpful. Halfway through paragraph 5, sir, when the owner developer Union Properties could no longer service its AED $1.3 billion dirham debt, its lender, via its property arm, Emirates National Bank of Dubai Properties, now generally described as ENDB or Emirates, took over most of Limestone House and the nearby Index Tower. The purchase totaled 101 units. The purchase date was 22 January, and the transfer date was 31 March 2012. The leasehold interest was transferred with the leasehold, whether the leasehold interest was transferred with the freehold is the exact subject of this dispute. 6. It's now common ground that Emirates had knowledge of the lease prior to the purchase. Later, it appears that available inference in an effort to appease its neighbour, the owner of the Ritz-Carlton, who had initially consented to the lease, but subsequently changed its mind about it. Emirates decided to rid itself...
Wait, Mr. Bowden, wait a minute. At para 6, you said it is common ground that Emirates had knowledge of the lease prior to the purchase.
Correct.
Mr. Montague Smith, is that correct?
No, that's wrong. That's not true.
Okay.
What?
Okay.
I accept there's a real prospect of successfully establishing that, but I don't accept it.
Okay. Okay, go on. I just want to make that correct that. I mean, when Mr. Bowden agree or not is another matter, but you disagree that it is it's not a common ground. Okay, then, Mr. Bowden, can you proceed?
Thank you. I'm genuinely surprised. Very surprised. Don't worry. It's like Mr. Montague Smith said, it's something that's very easily able to be proven, and I'll do that now.
Okay.
The master spreadsheet. Now, there's a master sale and purchase agreement and a master spreadsheet. The master spreadsheet is a key document. Now, and it's no more than a spreadsheet. It's an Excel spreadsheet initially developed by Union Properties. It was passed over to Emirates NBD, and now I assume the same document is in the hands of Zane Properties, who are the owner of the subject units now. Okay, so in order to manage its properties, Union Properties developed master spreadsheets for categories and classes of property. I'm at paragraph 7, sorry. i.e. Limestone House, Index Tower, retail, residential, and many of which listed the status of the units, leased or vacant, the tenants, the essential terms of any lease, and the rental. As discussed below, the first witness statement of as discussed below, the first witness statement of Moran Al-Maklafi contains no less than 36 references to and copies of the master spreadsheet of Index and Limestone House. That's the official title name which accompanied the document when we were given it. So what we're saying, sirs, is that when document production was provided, we received 36 different copies of this spreadsheet, and Ms. Al-Maklafi has sorted them out. The spreadsheet was adapted over time. The spreadsheet was adapted over time. My apologies, I've lost my place. I was just looking for something. I'll go to 8. The master spreadsheet was adapted over time as necessary by the additional deletion of columns and the alteration of data. The master spreadsheet formed the basis of and was attached to the office for sale for NAM 14 and 14, NAM 14 and 14A, and would have been an Appendix 1 to the master sale and purchase agreement, and it was handed over to Emirates as part of the sale documentation. The transfer date was 22 January 2012. Emirates used the master spreadsheet for the management of the units. 9. Emirates continued to amend the spreadsheet for its own purposes throughout the period of this dispute. Initially, the master spreadsheet recorded the lease as valid. Only from June 2013 was a new status column entered, which indicated the lease was anything other than valid. And if I just come down here, sirs, so it started with the 10-year contract, 10-year contract. In June 2013, a new status column was entered, and we'll just go and have a look at that if that's okay. And that's at NAM 65. So here, sirs, I'm at paragraph 113 of Ms. Al-Maklafi's witness statement, page D714. And here we are looking at the May 2013 version of the master spreadsheet, and it doesn't have the status column. But if we come down to 66A, paragraph 115 of the first witness statement, there you see, sirs, that they have inserted a status column for the first time, and that says expired or expire. Okay, but again, what is important is that the unit numbers, these units started as LP5 and LP6. They ended up as 17A and 17B transposed. It's got the contract rental in here, which is correct. That's the annual rental. It had the contract period. That's correct. That took it. It's still valid now. This lease, and the contract end date. And then just down here, it had the purchase price and the transfer fees. These were redacted, but it doesn't really matter. Critically here, the transfer date of the 22nd of January, that was the date of payment. And over here, this is the annual rental and there. So this document, by the time we're looking at it in July 2013, this had been in the hands of Emirates National Bank for something like 16 months. Okay, so we go back to 14.
What is your basis for saying that 17? Wait a minute. The plot numbers have always been 17A and 17B, is it?
Yes, sir. We'll come to that in a minute because we'll look at the survey plan. But when they were purchased, my apologies.
Okay, Mr. Bowden, before you proceed on, what is your cause of action against the defendant? What is your cause of action? Breach of contract, tort, yes. What part of tort?
First of all, sir, we're saying that we have a cause of action in contract, so that this is a valid lease, sir, and we're looking for
contract with. Wait. Contract with whom?
Contract with Emirates NBD, sir.
Was there a contract with you and Emirates?
There was a contract with Union Properties, and that was assigned to Emirates.
You say it was assigned to Emirates. So there is a liability on Emirates, right?
Correct.
If it is a liability, you cannot enforce against the person, the assignee, unless the assignee has acknowledged that liability.
I agree.
So if Emirates has not acknowledged the assignment, how could you put that liability on Emirates? basic what you learned in school, you know, 50 years ago.
Yeah, I accept what you're saying, sir, and the answer is that they have acknowledged the liability. There was a formal notice of atonement sent across saying that the contract is passed. We say that the Master Sales and Purchase Agreement, which we'll look at soon, also provides for the assignment at clause 1.1. We paid rent, sir, and as we're about to look at, they collected that rent. In fact, they fought for the rent.
For what period? For what period of did they collect the rent?
For the first year, so they collected the rent, and at all times, including to this day.
For the first year. For the first year of what? First year of.
First year, sir, following the purchase. So immediately following the purchase.
Purchase from UP.
Correct, sir. And the date of the purchase, we're just looking at, it's on the screen now, was the 22nd of January. So, and just to add a little bit of colour, sir, the
22nd of January, what year is that?
Transfer date, 2012, sir.
2012.
And so you see, sir, a slight wrinkle is that, unsurprisingly, the units weren't quite ready at that date. And there was a subsequent agreement entered into on the 15th of March to put the units on hold pending the completion of them. But other than that, sir, yes, Emirates acknowledged, well, first of all, sir, we say they purchased the assignment of the lease. That's how it got assigned. They purchased it. They paid money for it. They valued it. They paid money for it. They bought it. And then they took the rent. And then, sir, they cooperated in the registration of the lease, and their name went on the registration form, which they signed and stamped. So we say, sir, yes.
I don't think Emirates ever disputed that the property were transferred to them and registered in their name. What they're disputing is your lease was not registered.
Correct.
You are contending, you're basing your case purely on the spreadsheet. That's why I'm trying to how I understand. No, not just on the spreadsheet.
No, sir. No. I've got a mountain of documents, honestly, sir. So we've got a notice of atonement. We've got the proof of them actually collecting and receipting these rents, the rent. In fact, over these units, they actually argued about the amount that they were going to get. They went and picked up the post-dated checks. The cash was sent to them. So they had the cash transferred to their bank account for their pro rata share of this rent. And then, sir, they signed the lease registration form, and the lease, we say, was entered onto the register and became binding beyond doubt.
Okay, let me get the dates again. That the lease with UP was between you and UP. When was it signed?
There were two, sir. One signed in 2010, and then they moved units. It was originally LP1 and 4, and they moved to LP5 and 6 in December 2000 in 2011, sir. There was
the 5th of April 2011.
Yeah, 5th of April 2011. My apologies. The effective date we see here is the 11th of December.
So you signed and the transfer of the property was when? I want to make so that I don't have to search all over the later. The transfer was, when was that again?
2020.
I'm talking about the transfer of the property from UP to Emirates. When was it? Transfer?
Okay. The document we're looking at on the screen here, sir, is their internal records. The payment date was the 22nd of January, and the date of the transfer of the titles with the Registrar of Real Property was the 31st of March 2012, so 2 months later.
Okay.
Mr. Burden, while we're slightly taking off course, could I explore with you a couple of things that you've just referred to?
Yes, sir.
One is I'd like to understand what you mean by assignment of the lease. Your written submissions have referred to that on quite a number of occasions.
Yes, sir.
Referred to it earlier in what you said. As we all know, a lease is a rather funny thing. It's got two aspects. One, it's an interest in property, and two, it consists of contractual rights and obligations.
Yes, sir.
Now, what are you saying was assigned? When you talk about the assignment of the lease, what do you mean?
I mean, sir, the contractual interest in the lease. For example, if we...
Hang on a second.
Yeah, hang on.
Can we put aside any question of saying there's an assignment of the interest in the land, which I think we probably can, because the lessee can assign his interest in the land, the lessor obviously cannot.
Yes.
We agreed that far?
Yes, we are.
Okay, so what you mean is there was an assignment of contractual rights and obligations.
Correct.
Now, however, as we also all know, you can assign the benefit of a contract,
yes,
but you can't assign the burden.
Yes.
So what are you saying was assigned? In other words, what occurs to me is that in order for you to say that you have a contract with Emirates, or you ended up with a contract with Emirates, you have to say that Emirates' burden was assigned, or UP's burden was assigned to Emirates.
Yes.
Which I think you can say.
Yes.
You have to go as far as saying that there was a novation. In other words, a tripart arrangement taking the form, we, the three of us, agree that the lease between UP and Vegie is now a lease between Emirates and Vegie. Now, is that really what you are meaning by an assignment?
Well, yes, sir. It is exactly what I'm meaning by an assignment, and indeed, sir, that's exactly what happened.
Well, just hang on a second. I just want to understand. Yeah. So, what we are looking for is evidence which establishes a novation of the contractual rights between those three parties. Is that correct? Because
I don't think, with respect, sir, it's necessary to go so far as to say it's a novation, because they assigned the benefit of the lease to Emirates as part of the sale. Following
that is not,
which,
if I may say so, they did not assign the benefit of the lease. The benefit of the lease is the rights enjoyed by the lessee.
Yes.
Yes.
They did not assign that to Emirates.
Yeah. The benefit is now owned by Emirates. You are the the lease with you is a liability to Emirates.
Yes.
Is that what you mean, Judge Rogers?
Well, my puzzlement is to understand, Mr. Bowden, what is meant by an assignment of the lease, because it's, for the reasons I've explained, it seems to me that can only mean that there was a novation of the contractual rights.
Well, if I take you...
mechanism.
Shall we have a look at the key document which says that, sir? That is an 8.
Let me understand what you are saying. Yeah. Is that what you're saying? If not, what else are you saying?
Right.
Forget the evidence in support of it. Just let's get the concept right.
The concept, sir, is that Emirates purchased both the freehold and the leasehold interest in the unit. They purchased both of them. And that is what the document, the document which is missing would have said, and what the evidence establishes that they did.
Right. Well, that is contrary to what I thought we had agreed. The leasehold interest as an interest in land,
yes,
could not have been assigned or purchased by Emirates. Emirates purchased the freehold.
Yes, they did.
Well, I assume it purchased the freehold.
Yes,
I've got to say about that. But, Emirates purchased the freehold. That's what it purchased. It did not purchase the interest in land, being the lease.
Well, I apologize for any misunderstandings.
Hang on a second.
Yeah.
That remained, apart from any questions of registration and so on under the torrent system, with the lessee. It had that interest in land. It
Yes.
may not have lost it because it wasn't registered, but it had it.
Yes.
Now, so what you said about Emirates purchasing the interest in the lease, to me, I'm afraid, doesn't make sense. Can you explain it better?
Well, yes, sir. I would put it this way. The master sales and purchase agreement document that is missing, but which we have good evidence of what it in fact said, provided for the purchase of the freehold units and the assignment of the lease. And subsequent to that, sir, Emirates took that assignment and accepted their role as landlord, accepting rent, signing the lease registration form. There was a notice of atonement which actually set out the exact legal basis upon which this was transferred, sir. So yes, the contract which Vegie Bar had with Union Properties was assigned to Emirates.
Do you mean
Lock, stock, and barrel.
Burden of the contract?
Sorry,
Lock,
sir?
stock, and you cannot assign a contract lock, stock, and barrel. It's a legal impossibility.
I think what you meant, Mr. Bowden, is that the fact that, assuming what you say is true,
Yes.
that they collected rents from you
Yes.
shows that they acknowledge there is a
Yes.
lease from them to you.
Correct, sir.
If that is so, then that amounts to either the creation of a new lease,
Yep.
nothing to do with assignment, just that there was, by virtue of payment and receipt of rent, there was a lease, which is a well understood legal
Yes.
concept.
Okay.
So we forget all about assignment. Alternatively, you can say that that the evidence in some manner makes up a novation, which is a tripartite arrangement, which you may need to do, because if one asks what is the lease that arises by virtue of the payment and receipt of rent, it may just be a short-term lease. It's not necessarily a 10-year lease. That's what you've then got to grapple with, to show that the lease that arises by virtue of the payment and receipt of rent, or whatever else you can find, was a 10-year lease. Was
Okay.
the 10-year lease.
Yes.
So I'm trying to get the concepts right, you see, and I have difficulties with the fairly generalised statement, oh, there was an assignment of the lease.
I apologise. I don't want to blame anybody else, but in what appeared to be a flash of inspiration, it was Justice Sir Jeremy Cooke who said, what your client has purchased is the assignment of the lease. And I do say, sir, I rather gratefully latched onto that and have made it the basis of my formulation since. Perhaps I could come back and assuming that I was entirely correct in law on that, perhaps I could come back on that point, sir.
Yes, please.
I'm struggling.
And I hope that was just a loose use of language by Sir Jeremy, and that it doesn't mean that I'm totally wrong.
I can't blame him for my problems, sir.
May I ask my second question while I have interrupted? There's been the Chief Justice asked the date of the transfer of title, that is the transfer of the freehold from UP to Emirates. What I would like to see, if you could at some point find the materials, is that transfer now in the ordinary court. I would assume that the register is searchable and there'd be a copy of the folio which would record
yes, indeed, sir. I can take you that
transfer and so on.
If I it's bundle D2, sir.
So B for Barry?
No, D for Delta, sir.
Right.
And the official search certificate is the very last document set out there, and it's NAM 89, and it's on internal page 489 of that document, sir.
Thank you. That's fine. That's what I need. Thank you very much.
Okay, that's exactly where it is. The very last document in that bundle. And okay. But I think I might, if I may, go back to where I was.
I'm sorry to interrupt. I can no longer see the Chief Justice. I don't know whether he's still connected.
The Chief Justice is frozen on my screen.
Should I continue?
I don't think we have the Chief Justice at the moment. Chief Justice, are you there?
Sir, Ijaz here. Chief Justice called me. He said he lost the connection. He is trying to get back.
Okay, thank you.
Just a minute.
I'm now back, Justice Giles, at my supplementary submission at paragraph 12.
Thank you. I'm there. I'm with you there. Good. We'll wait for the Chief Justice, though.
Got back. Sorry, something went wrong here. Okay, I'm back here. Sorry, apologize to everybody. Where were you, Mr. Bowden? You were. I saw the pages moving on my iPad, but I lost your voice. I lost your pictures. But I think I know what you are trying to say. But what was your answer to Mr. Justice Roger Giles' questions? What was your response on the question of whether it's an assignment, it is a new contract, it's a new lease? What was your response to that?
What I'm saying, sir, is that this evidence is so strong that it in fact meets all of those possibilities. The master sales and agreement, sales and purchase agreement, in fact, used the word assign as setting it up. As to whether there was a lease taken on the same terms with the new Emirates' purchaser, that's satisfied as well. And as is the requirement for a novation, everything is satisfied because the evidence is so all-encompassing. And if I can, I think the evidence is the key to this case and needs to be properly understood. And the legal niceties of it become a lot simpler once one understands the evidence. If you will be with me.
That's why I started off by asking Mr. Bowden, what's your course of action? What is your course of action? Like 3 times I questioned that, because if I know what's your course of action, then we can look at the facts, we can look at the ingredients of the course of action, and we look at the facts that you allege fits in with the ingredients of that course of action.
Yes, sir.
That is why I asked you that question, you know.
Our cause of action, our primary one, sir, is that we say that we have a contract for a 10-year lease with Emirates.
Contract. That's one contract with Emirates.
Yes, sir.
When you say contract, it's on the lease. Lease, okay. Yeah. Anything else?
Well, yes, sir. We say that if the contract fails, equity should step in.
Yeah, what principle of equity?
Sorry, sir, the rule in
Walls against Lonsdale.
Yes, exactly, sir. The rule in Walls.
I don't understand that. Would you mind explaining?
Well, sir, the rule is that it was agreed that, well, Emirates has agreed, right, that it is the landlord. It has taken over all of the leases in the building, sir, and it has stepped in as landlord. So if there's some failure in the contract, sir, equity should prevail and move the contract across that way. I'm struggling, sir, with the concept that Emirates can come along, buy this building and agree to take all of the leases and then not be bound by them, sir.
Well, I'm struggling with the concept that you're trying to explain. Now, Walsh and Lonsdale is a way of completing a contract.
Correct,
that
sir.
is giving it, performing it, or
Yes,
requiring performance of it.
Yes, sir.
For that, you need a contract.
Yes, sir.
Right. So it does not create a contract.
Correct, sir.
So it's no use to you.
Well, we say that...
You've got to find your novation or your other contract in some way, in the way we've been talking about.
Yes, sir.
And you're able to come back and explain it, this assignment in some other way.
Okay. Can I continue with the evidence? And if I need to reformulate this claim, well, I will. And I think there's good evidence to support any proposed reformulation, sir. So, 12. I'm at 12 of the supplementary submission, sir. VB says that 2 master sales and purchase agreements tied together the mechanics of the sale of 101 units across 2 buildings, but those documents are missing. It says that Schedule 1 of the Limestone House MSPA was a copy of the master spreadsheet we've been looking at, and that Clause 1.1 provided for the assignment of the leases. Emirates says that the 101 units were governed by 101 individual sale and purchase agreements, and there was no unifying MSPA. VB says the evidence overwhelmingly points to the existence of an MSPA and says the MSPA governed both earlier and later sales to Emirates. The 2016 bulk sale of Limestone House by Emirates to Zane had a very similar agreement and used the same spreadsheet. So what I'm saying, sir, is that spreadsheet which recorded these units as leased was the contractual document which passed from Union Properties to Emirates and on indeed to Zane when it was subsequently sold to them. So I'm at paragraph 14 of that submission out. VB says that there was an MSPA. The document would have assigned the lease because the offer letter dated 18 December provided that 2 master sales agreements will be signed, 1 per each project. These master sales agreements will mention that individual SPAs for each respective residential, retail and commercial unit are to follow. The offer letter annexed as a schedule, the master spreadsheet. The offer included the proposed sale methodology. A draft of the MSPA was subsequently produced and forwarded to the Emirates. They sent it back, sir. In the end of December 2011, the final stock list was put together. NAM 20, sir, is a detailed report for each unit to be sold, and exhibits NAM 21, 22, 23, 23A all detail the finalisation of the master spreadsheets for attachment at Schedule 1 of the MSPA. Melanie Fernandez, the person who last had this document, was a senior manager in charge of the purchase. No final copy of the MSPA has been produced by Emirates, and Ms. Fernandez has not provided any evidence as to what happened to the copy in her possession. In defiance of the Court of Appeal's ruling of 18 January 2018 for document production, Emirates put the same executive in charge of locating the MSPA, and unsurprisingly, that process failed to produce it, and they've never asked their lawyers for it either, sir. Now, if we look at the terms of an actual MSPA, sir, now we don't, what I've just set out is the very good reason to believe that there was going to be one, because they said there was going to be one. A draft was produced, a draft was circulated, the draft was chased. If we look at an actual MSPA, it says this, sir. Emirates did manage to produce one for inspection. Clause 1.1 provides, and if you wish to look at it, we simply click this hyperlink here. Clause 1.1, the buyer agrees to purchase and the seller agrees to assign, sell, transfer, convey and dispose to the buyer all of the seller's rights, titles and interests in the property. So do you wish to see that document, Your Honours? Right.
But this particular document does not relate to your property, does it?
No, sir, but we say
you are alleging that the MSPA involving your property, yes, contains the same clause.
Correct, sir.
If the buyer agrees, let's assume it is true. The buyer agrees to purchase, and the seller agrees to assign, sell, transfer, convey, and dispose all of the seller's rights, title, and interest in the properties. But yes, you are not a party to this contract, to this MPS and MSPA, are you? You are not. No. This is a bilateral agreement between the buyer and the purchaser only.
Correct, sir. Mm. But okay, it assigns the burden of that lease.
Why? What words do that? Just to follow up our previous discussion.
I didn't think you'd let me away with that, sir. Well,
in that case, shouldn't have even said it, if you don't mind me saying so. Let's try and get to the point.
Well, doesn't it do that, sir? assign, sell, transfer, convey, and dispose all of the seller's rights, title, and interest to the properties.
Yeah.
Does
what
that
is
not?
seller's right, title, and interest?
Yes, sir. And why does that? Sorry, I'm talking across you. My apologies.
Not at all. Go ahead.
Well, my question is, sir, why does that not include the obligations attached to the lease? If these were the terms and there was a schedule which included this lease attached to that document, with respect, sir, why does it not include the burden of that lease? Mentions the lease.
Right. Okay.
Okay, let's not forget, Mr. Bowden, this is your application for an immediate order, isn't it?
Well, yes, sir. But
this is immediate order. If this case goes for trial, you can examine, you can cross-examine everybody to prove your case. But for the purpose of an immediate order, is this good enough? That is the question. Immediate order. It is not a trial. You know, if it is trial, it's a different thing. Then you can interpret. You're asking us on the face of the record, so to speak, to accept that you have a good case. You have a case against Emirates. That's what you're asking us to do. That is what the judge of first instance was reluctant to do.
If I was just...
You have gone for trial, you have gone for full trial, produce the witnesses, hear the cases, and the court can decide whether Ms. Fernandez is telling the truth, examine the document one by one, then, I know, you may be able to prove your case.
Indeed, sir, I agree. But it's not just... Okay, can I answer the
Yes.
It is not just immediate judgment that I'm seeking. I've also got document production requests, sir, and one of which is that Emirates get sent back to find this document, which everybody said was going to be executed. The last copy was in their hands, sir, and no one has ever said that it wasn't executed. And it must be there, and they haven't even, sir, gone to their own lawyers who must have retained a copy of it after they drafted it, sir. So I agree. It is an unsatisfactory basis to say, well, I want immediate judgment on a document that I don't have. I agree. I want to go to trial if it's necessary to do so, and I want this document to be there when I get there, sir. And that's another thing I'm asking. So if I don't get immediate judgment, I do want an order for the production of this document, because I've just set out, so there's good evidence that it exists. Now, can I realised...
No, sorry, go back, rewind back. What are you claiming? What are you claiming in your main suit? What are you claiming for? Are you claiming for damages? Are you claiming for... what are you claiming for?
My client, sir, he wants to enter into the lease, sir. Yeah, he wants specific
performance.
Yeah. If he doesn't get that, sir, he wishes damages in lieu.
Okay. Judge Roger, you wanted to say something, Judge?
Yes, I did want to say, in Mr. Bowden's interests, he wants today not just to say that he should have the opportunity to prove his case at trial. He is trying to resist the immediate judgment against him. So for that purpose, Mr. Bowden wants to say he has an arguable case that should go to trial. So there is a question whether what has happened was appropriate for immediate judgment or not. So there are the two aspects. Mr. Bowden, I don't think he did bring it out.
This is like a striking off, then striking off by Emirates, is it? Yeah. Striking off the claim by Mr. Bowden's client.
Yep. It's got some judgment against Mr. Bowden, so he wants to get that set aside. So he
Get
wants
some orders that he's seeking for. Yes.
Yeah, he wants to. He'd like to get summary judgment in his favour, but if he doesn't get that, he would like to go to trial.
Correct, precisely. Now I'm at it must be 17D of my supplementary skeleton. I'm just about finished this introductory part, and hopefully we'll skip along after that. But looking at the MSPAs that we do have, the copy ones that we've got from the next year, same parties, same building, same sort of unit, different units. But so looking at the actual specimen copy we have got, which we say would have the same terms, it says this, 3.3, immediately following the transfer of title into the name of the buyer, the payment of the purchase price, the seller shall hand over physical possession with the benefit of the leases. So this MSPA, which we're missing, and we say Emirates have been a bit naughty about it, they just haven't come up with it, and it was last in their possession and provided no excuses. Shall hand over physical possession of the properties with the benefit of the leases to the buyer. The seller shall hand to the buyer all the lease agreements and post-dated checks of the rented properties and any relevant document that allow the buyer to collect the rent for the tenants. The seller shall not be entitled to receive any rent from the properties, however, if any, should say rent, received by the seller after the date of receiving the purchase price, the same shall be transferred to the buyer immediately. Now, what that intends to say is that there shall be a pro rata distribution of the rental. And that, sirs, is exactly what happened. So what was provided for in the body of the MSPA, which Emirates did produce, exactly matches what in fact occurred in the sale process under consideration here, none of which was provided for in the individual SPAs. So I'll just come to Emirates' case now, sir. Perhaps it's in reply, but I'll deal with it as we speak. Right. So Emirates say there was no MSPA. They accept, yes, well, they have to accept they were the last ones to have a draft. They've produced nothing to say that there wasn't one. There was never an email that went about saying, oh, we're not having one, anything like that. It's just disappeared off the radar. We say, for the foregoing reasons, there must have been one. How did they do this pro rata thing? Well, what they rely on is the individual sale and purchase agreements. And in particular, sir, they rely on 3 words out of clause 4.1a. They rely on the words possession and occupation. And they say, well, that lets us off any obligation in relation to this lease, but we got possession and occupation of the property. But this perhaps, Justice Giles, comes back to your point, the point you were raising. The property shall be given to the purchaser, and I've underlined it, my emphasis, sir, and all risk in and benefit in the property shall pass to the purchaser. So we say, sir, my learned, he wants to talk about only those first 3 words, and his submissions only mention those 3 words. When you look at the actual clause, and we'll just quickly pop and have a look at that, here is the document itself, sir, and it's under D, evidence folder D3, page number D1231, and if we come down to that, sir, I've just marked it there with a pen, 4.1, provided the purchaser has fulfilled the obligations in this agreement, and is otherwise not in breach of this agreement, he shall, possession and occupation of the property shall be given to the purchaser, and all risk in and benefit in the property shall pass to the purchaser. And in my respect for submission, that is the burden of the lease. And I'm back now to my skeleton, and I'm going to paragraph 20, and we're coming now to a key document again. Sorry. So, with respect to Emirates Council, their reliance on those three words is more than a little misleading. Other key points are this: the SPA upon which they rely makes no mention of either leases or rent, but we know many properties were rented, and we know all of those properties were sold and the leases are signed, with quotation marks around that word now, Justice Giles, I'm regretting ever using it. It was only this lease that suffered. B, no mention is made of the pro rata division of rent, which we know occurred. The property has it should say it has a assignment date of the 11th of January, but that was not the date of either payment or the transfer, which was 31 March. However, we know that the transfer date, this payment date should have been, was 22 January. That date's not mentioned in the SPA, and there's no provision for the transfer of funds in any of those SPAs. There weren't 101 payments. There's 101 SPAs, but there were not 101 payments. There was one payment on one day. The SPA does not provide for payment or even a date for payment. So it can't be a standard, you cannot be 101 stand-alone transfer or agreements for sale and purchase which governed all aspects of the sale. It's impossible. And they didn't act in the way that Emirates would contend that they must have if there was only the individual SPA. So, Emirates' entire case is predicated on the absence of any provision in the SPA for assignment. For example, and as discussed below, when Emirates said from December 2012 that the units were not subject to a lease agreement, which meant the lease was not noted on the title deeds by the RORP, Emirates says this was not a fraudulent misrepresentation. It says it was true, because although it admits there was a lease, it says it was not binding on Emirates because the SPA does not assign the lease. Conversely, if there was assignment or related registration, the statement was untrue. Emirates' case in its entirety rests on the slender proposition that there was only individual SPA. That, in turn, rests on the court's acceptance that there was no MSPA, a proposition which itself rests on an acceptance that Emirates cannot find the document and therefore it does not exist. As Emirates accepts that document production was inadequate, that with respect seems unlikely, because my learned friend apologised for the absence of document production at the hearing and said that they would fix it, and they never have.
That is simply not accurate.
Well, we can go, if you like, we'll go to your transcript at pages 10 and 11, and we can see exactly what you said, my learned friend. That is what you said, and it's there in the transcript. I'm not making it up. Now, here's the critical point. Notice of atonement. On the day before the hearing, Emirates produced 76 pages of additional evidence. This included a document which did not get the attention at trial that it should have. This was the notice of atonement, a copy of which was provided by Emirates to VB to give to the Registrar of Real Property to establish that Emirates was the owner of the units and consented to the registration of the lease. And in a different context, we'll come back to this correspondence I'm talking about. But what I'm saying was that the lease was registered on the 28th of May. Just leading up to the registration, the Registrar of Real Property wanted to know that Emirates consented to this registration, over and above them signing the form and stamping it. And so Vegie asked Emirates to provide proof that they consented to the registration of this 10-year lease. And they provided this document here. And I'm at bundle D. I'm not sure if your computer's caught up, Justice Giles, but I'm at bundle D, and it is tab 6, D6, and it's at page 1288. And this, sirs, is the notice of atonement. And I understand a notice of atonement is something that it goes back to medieval England. When one lord knocked off another lord and you got a new lord, you received from the sheriff a notice of atonement to say for all the serfs that you would pay your rentals to the new lord. and that's the basis of an order of a notice of
Okay,
attorney.
I'm not familiar at all with notice of attorney. I know a power of attorney, but I don't know what a notice of attorney. In the context of your case, notification of a new owner of limestone, or a notice of attorney is a notice given to the new owner or the old owner, Vegie bar, or to the tenants, to the tenants.
Tenant that their contractual interest has been transferred to a new party, and you see there. So this is addressed. It's from. I went too fast. It's from Union Properties, okay, who were the old owner, okay. It's dated the 1st of March, so it's after the payment, but before the title transfer, before it's noted on the title, okay. It's addressed to Vegie bar. It's sent by registered post, and it says notification of new owner. This letter is to inform the lessee that of the transfer of ownership of the above unit to Emirates MBD. Union Properties will no longer be managing the unit. Your contractual interest has now passed from Union Properties to the above named company. And that
your contractual interest.
Correct.
That means Vegie bar's contractual interest with Union Properties.
Yes, sir.
Has now passed to Emirates
MBD. Yeah. And it gives the familiar name there again, Sir Maria Fernandez, Melanie Maria Fernandez. And
any maintenance issue, please contact Maria Fernandez. It will be endorsed and transferred to new owner in the case the checks cannot be transferred. Okay, for parties. Oh, I see. Okay, it's a notice of assignment. Notice of assignment. Yeah, okay. Yes, anything. Who was speaking?
Mr. Boylan, I mean, this is Judge Ali. But still, this letter does not amount to that Emirates accepting what you call as an assignment or novation, as Justice would like to describe. Okay. Just a notice between the seller of the unit, the property, and one of its tenants. So this is just between you, and still Emirates has to clearly accept that.
Well, I think the answer to that is two things, sir. This proves that the transfer of the contractual interest that we were looking at in the MSPA and the terms of the MSPA before. So this is good evidence of that. But the other thing about this letter, sir, is that this copy was actually in the hands of Emirates, and it came. Our client obviously was given a copy, but this copy here came to our client from Ms. Fernandez when they went to register the lease. So at that time, they asked Ms. Fernandez, can you tell the RORP that you agree to the transfer, to the registration of this lease? And as we'll see, we'll come to this documentation. She sent this, Ms. Fernandez sent this document to them to give to the RORP to prove that they were indeed the landlord and that they consented to the registration of it. So on its own, I agree, it's a notice from one to the other, but it fits with all the factual matrix, and it fits with and it dovetails into the argument that these parties did intend to transfer the burden of the lease from Union Properties to Emirates MBD.
Mr. Body, you're not recreating the wheel. I mean, Emirates never said we did not bought the building or the property. They're admitting the purchase of that property, which is this letter. Intend to establish. So I don't think this letter is taking you any way further, apart from someone says the building is being transferred. The letter itself does not does not record the transfer of obligations that you're trying to refer to.
Well,
apart from the maintenance.
I think it does.
No, the second paragraph of the letter. Your contractual interest has now passed from Union Properties to the above company. your contractual interest is Vegie Bar's contractual interest. You are saying from there, Mr. Bowden, the way I understand is, by virtue of this letter, there is now a contractual relationship between you and the Emirates. But the question is, has Emirates acknowledged this contractual interest? Your answer is yes, because you have paid them rental.
Correct.
For 2
That's
months.
what we come to next. Yeah, yeah.
And then
it's
their intention is reflected in the balance sheet.
yes.
There's sorry, not balance sheet, fact sheet. Fact sheet statement shows that your name was in the one of the earlier fact sheets that you got, and later on your name was removed, or your name was removed from there. Yes.
There's 36 of these spreadsheets. Not one. It's not an accident. There's 36 separate versions of it, and so yes. To answer Justice Madhani's point, I agree that this is not the contract, or this is not the contract, but it is evidence of the contract, and that's what I'm saying. It evidences a contractual transfer that has occurred, right? That they have agreed to buy the building, and they have agreed to take over the lease, and this is evidence of it, because they're telling the lessee that this is to inform the lessee of the transfer of ownership. Your contractual interest is now passed. Your checks have been endorsed and transferred. The cash has been paid over. If you've got any problems from now on, you contact Melanie Fernandez. And she, of course, subsequently, 3 months on, she gave this to our client to prove that they agreed to the registration of the lease. And to answer your question, my key point and my best piece of evidence in all of this, we haven't got there yet, is the registration of this lease. But all I'm showing is that it all dovetails together. Right. My learned friend will be chastising me very shortly for not being fast enough, so I've got to keep moving. I apologise. The evidence of the collection of rent, and this is just where we were a moment ago, Chief Justice. So I'm at now paragraphs 24 and 25 of my skeleton argument, sir. And so, following its purchase, as stated, the most compelling evidence that Emirates purchased the assignment of the lease, and I really wish I hadn't decided to hang my hat on that word, Justice Giles, and I'll come back to you. I'm good on facts and short on law. But Emirates purchased the assignment of the lease is the fact that it subsequently collected rent. 25. Following its purchase, effective 22 January 2012, Emirates set about collecting that rent. The master spreadsheet shows that Emirates believes that it was due the following sum. And so I'm just at paragraph 25, and you see, then Chief Justice, you see there, I don't know if you can see the blue circle.
Mm.
That's my circle. That shows, that's the annual rental, okay? And it's got a annual rental, the end of each year is November, okay? And so Emirates calculated that they were due 314 out of 365 days of rental, and they calculated it as being 126,000. As we'll see, that figure there of 126,000 is actually 313 days of rental, but it's just a slight spreadsheeting error and very close. So the receivable sum is hardly an accident, as the sum numbers broadly match the expected pro rata division. So when I wrote this, I didn't realise that it was 1 day out, and I couldn't quite work it out, but it's 1 day different, okay? It's not possible to ascertain the exact calculation. I now can. It was 313 days. but it's within a few hundred dirhams. It's obvious that almost 5 months after buying the unit, it was seeking its pro rata share of the rent. And this, of course, goes back to the MSPA, because it was the MSPA at clause 3.3 which said that we're going to have a pro rata division of the rent. The sale and purchase agreement, which my learned friend relies on, this says nothing about that. So this is to say that the terms that we believe will be in the MSPA are there, because what happened on the ground matches what is set out in the documents that we do have. Okay, so I'm at paragraph 28. Proof that acceptance and calculation of the rent was no error is manifest. NAM 36 and 36A shows a detailed calculation to work out the rental due for the VB units. And sorry, unless you want to, I'm not going to take you to these spreadsheets because they kind of repeat themselves. But what they were doing, there was a long process backwards and forwards where they argued over really a few hundred dirhams worth of rent. NAM 40 shows Emirates proposing a rental settlement. NAM 41 shows UP responding with its calculation. The accountants got really busy on this, sir. NAM 41A is the agreed reconciliation for the 22 January 2012 being the payment date agreed in the master sales agreement. Of course, in Mr. Montague Smith's agreement, it's the 11th of January. So they were working towards the date in the master sales agreement. Limestone, and it says Limestone House retail leasing, final reconciliation, 22 January 2012. The document deals with VB leases in the same manner as the other leases. Furthermore, the yellowed portion, that's here, sir, just below. The yellowed portion demonstrates that the amount payable has been subject to detailed calculation, and the amount claimed by Emirates reduced by 262 and 403 dirhams. So, sir, they were fighting over 465 dirhams in relation to these leases, which really goes to prove that it was a very deliberative process that was entered into. 41B, and I've just set out the spreadsheet there, which shows them actually agreeing on it. And these last two columns at the right-hand side here, where my cursor is just moving now, shows Emirates MBD cash payable. So Emirates MBD were paid 10,000 and 15,000 in cash for rental, and over there they were paid the security deposits of 8,000, another 20,000 in security deposits. So 45,000 in cash went across from one to the other, plus the checks. Okay. 41B, they ended up with complete agreement, and then I'm down at NAM 43, records them on 30th of August 2012. Kindly refer to our meeting with the UP team earlier this month. We have agreed on details as per the Excel spreadsheet, same spreadsheet, and security deposit receivable by us. We have collected the PDCs of the tenants from Union Properties. The collection of the checks, included the VB post-dated checks. So they went and picked up the checks. Okay. Just there, NAM 44 to 44C, that was, again, them organising the payment across of the money. And there's no doubt at J, what is relevant is that VB paid 132,440 in cash and was always 3 months ahead in its rent. Now, what does Emirates say about this? What my learned friend says, and is going to tell you, he says, with respect to him, at its highest, this evidence might be consistent with the individuals involved believing that the lease had been transferred. So what Mr. Montague Smith QC says is that this is all an accident. But with respect to him, there's not a shred of evidence that any of these people didn't know exactly what they were doing and that they weren't intending to do exactly what they did. It's all copied to the highest levels. It's copied to the senior executives and copied to the CEO of his client company. It cannot, with respect to him, have been an accounting or as he says down here, an accounting error. Paragraph 79, he says, even if the accounting was done on the basis of an erroneous assumption, accounting errors happen. And indeed, Lord Chief Justice, this is perhaps where the equity does kick in, because if you set up an assumption, you are bound by the result. If you allow people to assume by your conduct that you are acting in a certain manner, and they act in reliance on it and change their position in reliance on it, which Vegie Bar did, you are bound by it all the same, even if it is a wrong assumption on your part. But the point for us, sir, is that there's no evidence that any of this was a mistake. I've said it there, sir, 31. There's not a shred of evidence from the half dozen Emirates officers involved in the collection of very substantial sums of rent from a large number of tenants that this was a mistake. The alleged
please pause there for a while. Are you saying that your client actually paid those amounts to Emirates?
Yes.
They
well,
did
he
pay.
paid them. He paid them to UP. UP paid them on to Emirates. Yes, sir.
No. I'm talking about after Emirates has taken over. After Emirates has taken over, do your client continue to pay the rental to Emirates?
No, no further payments were made. Because there's two reasons. So they took, he was always 3 months in advance on the rent.
Yes,
because part of the problem is that this building wasn't ready, at the time we're talking about, it wasn't ready for occupation. And on the 15th of March, they agreed to put the rental payments on hold, pending the completion of the building, so he could move in. And we'll see later on that he made effort after effort after effort for years, actually, to try and get in there, starting from December 2012. So by the time that the building, he described the building as being ready for occupation, Emirates had changed their mind about this lease and told him to go away and repudiated it. That's what happened. But so he didn't need to pay any more money. But yeah, Emirates took the money, or part of the money that he had paid. So he paid 132,000 as set out above, sir. Emirates took 45,000 of that. UP retained the balance, and Emirates took the cheques. And in August 2012, contrary to the agreement that they'd reached, they banked those cheques. And unfortunately, they bounced. But
checks bounced.
Well, they did, because there had been an agreement that the cheques would be put on hold. So my client moved the money out of that account and used it for something else. And in the meantime, against that agreement, sir, they banked them. So. And they never gave them a chance to sort it out either. They simply said, well, your cheques bounced, your contract's cancelled. So,
okay.
I mean,
under your original agreement, so-called lease agreement between you and between your client and UP, when was lease supposed to commence? After the building is completed, or what? I've not cited the agreement. What was
date? I believe, sir. Allow me to come back, but it was November 2011. It was in those spreadsheets there. So that was. I've got somebody checking on that right now, but it's in the spreadsheets that it was supposed to start in November, 1st of December, I think. But it was by agreement put on hold pending the completion of the building and settlement of the leasing situation. They had a discussion.
It was originally started on 1st of June 2011 is the date in the lease.
Yes, sir. And that was subsequently put back on several occasions.
Well, the only occasion I'm aware of is the one where they said we'll defer it until other units have been sold.
Yes.
That's what you're.
Yes, but as I understand the evidence, that even prior to that date, the actual rental hadn't kicked off. He had paid the security deposit, and he had paid the marketing fee, and he had paid the fit-out fee, which allowed him to get in there. But he didn't at that stage get the keys. So yeah, the only formal agreement I agree is that 15th of March, but the rental, he hadn't had the keys basically. So rental starts when you get the key.
No, it doesn't. The rental starts when the lease says it starts.
Well,
the lease starts when the lease says it starts.
Yes. Okay.
He chose not to get the key for some reason or other. That's a different matter. The lease was still running.
Yes,
wasn't it?
I agree with that.
Yes, on the black letter, of course, you're yes.
But it is nice to be accurate.
I apologise. On the black letter of it, you're correct, sir. What I understand from the evidence actually occurred is that even by the 15th of March, he hadn't entered, and at that stage it was agreed that the rental would be put on hold and the cheques would be put on hold until everything was ready. As I understand it, and there is some evidence about it, sir. Plant boxes weren't in, minor stuff, but you know, there's always a run on. Okay. If I may, so all I can really add about this is that the collection of the rent was exactly what the Master Sales and Purchase Agreement mandated, and that is why they were doing it. The SPA's made no mention of it. There was never a mistake. The correct collection of rent does not create an assignment, but it's proof of it. The registration, and here, sirs, is this I would like to say is the high point of my case, because Emirates are bound by this lease because they consented to the registration of it, and it was a 10-year lease that they consented to the registration of. And here's the law's pretty. The requirement for the registration of a lease is a low bar, and that's set out in Article 55 of the DIFC Law of Real Property. And just to be clear, there has been a subsequent amendment of the DIFC, or a new version of the DIFC Law of Real Property in 2018, and in particular, it cuts out 31H, which we'll discuss soon. In order to be registered, a lease must include a description sufficient to identify each part of the lot to be leased. That is all that is required. That requirement was well met by the lodging on the 16th of February 2012 of a detailed cadastral plan of each unit. So one of the arguments in the court below was that this lease does not exist because the units didn't exist. There was no defined part of the units which could be leased. There's no, and that was simply incorrect. And even we had this evidence in the court below, and the judge was taken to it at length. And I'm just moving to it now. It's coming up on your screen. And so that is, it's for Justice Giles, it's D5, and it's D, page top right, D1283. And that, sirs, is the cadastral plans for these two units. And so I think what's important and what's useful, what would be more useful if I could rotate it, is the dates. Sorry, if you can, I'm not sure I can rotate it. It's dated up here on top right, 17th, the site plan's the 17th of December 2009, but the date of this plan is the 16th of February 2012. And in correspondence which I had with the RORP, sir, he has said, take this as the approved version of the plans. And indeed, sir, it's stamped by the Director of the Land Department, and it is the DIFC approved cadastral plans. And indeed, to answer your earlier question, Chief Justice, this is how the unit names got to be changed from LP5 and LP6 to R, presumably for retail, 17A and 17B. So the units which had been on site plans earlier, these are the as-built plans done by a firm of registered Australian surveyors indeed, and sets them out. I don't think that there's anything more to discuss about that. Unless there is, I'll move back to my submission. And so now we're back down to, okay, now here we come back, and here we dovetail back into the notice of atonement shortly, sir. Emirates willingly participated in the registration of the lease on the 28th of May. There was no reason why it should not have. It was the landlord, and at that time it was collecting rent. Indeed, it goes further than that, as Emirates were obliged by law to register the lease themselves and face a fine if they did not do so. And I have marked up all of the provisions in the law of real property. I'll come to that shortly. So NAM 34 shows that in early May 2012, Emirates was in the process of registering documents with the RAW. There can be no surprise that the Vegie bar lease was registered at that time. Indeed, the master spreadsheet exhibited in NAM 35 demonstrates a precise record which Emirates had of the VB lease on the eve of May 2012. So I'm down at paragraph B. NAM 37 is the lease registration form. This single most important document proves the registration of the lease being signed and stamped by three most important players: Emirates manager Melanie Fernandez, VB's manager Naki Al-Khalili, and the RAW Jabba Al-Sawaidi. Widely disparaged, it provides proof not only of the intention to register the lease, but the registration itself. So if I go now to that, and that, sir, is in D, well, I'm now in the witness statement of Nuran Al-Maklafi at paragraph 60, and she has transposed here that she's copy typed the details of that form into this document, sirs. So it shows what was being, and we'll have a look at the actual form in a moment. The applicant name, landlord, Emirates MBD, and that's the registration, that it was actually Emirates' obligation to register this lease. It wasn't the tenant's obligation, it was Emirates' obligation. The tenant name, Vegie bar, property description, retail, unit numbers. They used the old unit numbers, I don't know why, they had the new ones by then. Shows that annual rental, and that's exact. That's the exact annual rental, 250 odd thousand. Shows the lease commencement date, shows the expiry date. It's actually wrong, it's next year. Nobody seems to be able to add 10. It's wrong all over the place, but that's what it says. Option to, if applicable, renew. And then the form is stamped by Vegie bar and signed by the parties as follows. And if we actually just have a look, and I'm at D893, and so it's D2 Justice Giles and page 893, and here we see what was actually done. So that's Vegie bar signing it. That's the Vegie bar stamp. That's Mr. Al-Khalili, the director of Vegie bar's signature on that. It's signed by Emirates MBD. That is Miss Fernandez's signature. And then signed by Vegie bar, stamped by Vegie bar, and it's signed there by Jabba Al-Sawaidi, and he is the registrar of real property. So, and it's dated on the 28th of the 5th, 2012. Here, and it has to be said, sir, my client, bless him, is not the best record keeper. And at the beginning of this case, this document we're looking at here, the receipt, was in fact the only evidence we had of the registration of this lease. So we've come a long way. So he started with he kept the receipt for $367.50, which is $100 US, which is the scheduled payment for it. And indeed, sir, the lease number is recorded again on the next. That's the receipt number 1308, if we come down to the next document, Susan, I'll just blow it up if I may.
What's that noise going on? What's that noise? Who's causing the noise? Hello, Ajaz?
It's not me.
Ajaz?
Yeah.
Who's causing that noise? Ajaz? Jajali? Oh, anyway, Registrar, Maida?
It's not on my side.
Can you find out what's going on? Oh, no, stop.
Yeah. I think I've seen Mr. Montic Smith has dropped from the call, maybe.
I'm still here.
Oh, yeah, okay. Yes.
I can see you, but I hope you can still see
All
me.
people, although you've become a bit furry, and I do have a noise, a tapping noise.
Well, I've been on mute, so hopefully it's not coming from me. I can drop off and reconnect if you prefer. I don't think it is me, but I can try it.
I just muted mine, Tom, and to test if it was me. It's not me, I'm pleased to say.
Okay, I'll mute and see what happens. Okay.
Much better.
I think I need to confess I had pushed some papers onto a keypad. So I think I was it. My apologies.
As we're now on. I'm now looking at the actual register kept by the registrar. So we'll come to it shortly. But there were difficulties in creating the folios and therefore creating the certificate of titles and the search titles, which were subsequently created in 2014. Okay, so this was in 2012, and so what they were doing at that time, and this is not the Registrar of Real Property, but this is DIFC Registry Services, which has its own director and serviced, well, it was a record-keeping arm of the entire DIFC, as I understand it. But and relevantly, it kept a record of leases on behalf of both the Registrar of Real Property and the Registrar of Companies. And of course, the latter being relevant because without a lease, you can't register a company in the DIFC. So Vegie Bar needed this lease, and they needed it to be registered in order to get their company registration. And they needed their company registration in order to get their alcohol license, in order to open the bar next door to the DIFC Ritz-Carlton, which was the whole aim of the enterprise in the first place. So if we look here, wait
a minute. You mentioned something about the bar, the alcohol bar is not going to be in the IFC. Did you say that just now?
What I'm saying, sir, in order to open a licensed restaurant in the DIFC,
yes. Okay, I understand that.
Had to be a company. In order to be a company, he had to have a lease, and that and it had to be registered because the registrar of companies accessed that data in order to approve the registration of the company. You see?
Yes.
So,
and then, you went on to mention something about you want to open a bar and next to the IFC.
Well, yes.
A bar. You did mention that. Is the bar, which is supposed to be illegal in the IFC, was it supposed to be open in the IFC or next to the IFC? Very critical.
In the DIFC, sir. He obtained the alcohol license. He got it. Yeah, hard to get. Yeah, he got it. Yeah, very difficult to get, but he got it. So he obtained the license. He hired the staff. He employed the chefs. Vegie Bar, sir, is a long-running, very well-established restaurant in Melbourne, and he'd been to Melbourne, and he had been to Vegie Bar. and he befriended the owners, and he got a license, if you like, to operate. He was so taken with the concept that he said, I want this in the DIFC. And that's how it all got started, sir.
Okay, just proceed.
So, yeah. So here we are at the lease. And so if you can see this document, it's not great, but if you can see this document here, it says 28 May, number 1, row 1, sir, 28 May, Jabba al-Suwaidi, we know he's the raw, the name of the lessee, the unit numbers, that's that receipt number that we were just looking at immediately above. It's got the lease commencement date and the lease expiry date. So somebody's actually fixed up the information on the form. The form had 2020, it's actually 2021. The contact number, that's my client's contact number, sir. Finance at Amica Lounge, well, that was his email at the time, sir. Amica Lounge is another bar that he had uptown in the H Hotel, just to answer that. The leasing details, that was his address, and the landlord details there, Miss Melanie Fernandez. So that, we say, is the register. Now, just on that point, my learned friend, he's going to disparage that and say it's just an internal spreadsheet kept by the Raw. Well, it wasn't. And if I just quickly take you to another document which really proves this, and if we go to the 7th witness statement of Naki Al-Khalali and the exhibits to it, so we're now on E11's, Justice Giles, and this was before the Court of Appeal last time. And if we go down to, I'm looking at the index, it's exhibit number 3 at page 6. And again, we look at we're just flicking past documents we've seen, but that takes a while. Here's where it gets important. Okay, so I'm just stopping here at document E1575. This is dated the 29th of May. This is the day after the registration. This is the Registrar of Companies, Khalid, and that's, I'm assuming that's Khalid Al-Zarut, or absolutely it is, because it's got his name at the top, sorry. He's the Registrar of Companies, still, Khalid. The above captioned entity requested to renew the commercial license has satisfied all the ROC requirements. The lease is valid for 10 years from the 1st of June 2011. And I do apologise, Justice Giles, and you were entirely right before about the date of the commencement of the lease, and I was wrong. Lease registered with the Raw. Enclosed is the commercial licence for Vegie Bar LLC for your signature. Okay, so that's how he got his company licence and the add-on alcohol licence. And so it's reviewed. Now, here are the other, this is from DIFC Registry Services, sir, because it wasn't an internal spreadsheet kept by the board. DIFC Registry Services kept these for many buildings. So this is the one, an identical form that they kept for index towers. And here we have the subject one they kept for Limestone House. Okay. And here we have the one they kept for Damac Park Towers. Okay. And here, this is lease registration Liberty House, which is another large building in the DIFC, and with a large number of leases. And here for Emirates Financial Towers. So the suggestion, and it's showing, if I just blow this up, that various people are registering these leases. Yeah, these are leases. So Jabba Al-Suwaidi, he is the Registrar of Real Property. Khalid Al-Ali, he, and the documents show below, is the Director of Registry Services in the DIFC. So this was, and we'll come to it in a minute, but the reason why the titles could not be issued for Limestone House in 2012 related to a building coverage dispute between Union Properties and DIFC Investments. So it had nothing to do with Vegie Bar, and indeed nothing to do with Emirates NBD. And it's indeed in the sales agreements, the offer for sale and purchase, it discusses this problem in there rather obliquely. But so Union Properties had not itself managed to obtain clear title to the property when they sold it to Emirates NBD. So it was all sold on the undertakings that they would fix this problem up. And they did. And so when they resolved the problem in 2013 and finally 2014, the titles came through. And so in the meantime, that's how they were keeping the register. And they weren't just keeping it for for Limestone House. And they weren't just keeping it for these two leases. They were keeping it for dozens across many buildings. So one must assume that other buildings had similar problems, not the same problem. And these documents I'm just coming to now, and sorry, Justice Giles, I'm on E1581, and this is how this lease, how we got the copy of the lease register. So this is an email to Mr. Jabba Al-Suwaidi. I'm sorry, and as you know, in email chains, they're always back to front. So we'll go from the last to the first. Dear Jabba, please find attachment as to your request. And that's the attachment of those documents, the register as we've just seen. So Assistant Manager Registry Services. We come to the next one from Mr. Al-Suwaidi, who's the RAW. Please, I appreciate it if you could share with me the exact information. Sorry, this one. This is from Khalid Al-Ali, Director, Registry Services. It says here, and this is on Thursday, July the 11th, 2013. So this is a year after the actual registration form has been signed and stamped and this fee paid and it's been registered. 1 year later, 14 months later, it's still registered and kept by the Director of Registry Services. And he says, Dear Jabba, the lease registration information requested is available on the P drive, okay? And then if we come back down here, this is the original reason for the request. Again, nothing to do with Vegie Bar, but this is an internal memorandum which proves the veracity of these lease registration Excel spreadsheets, that they are in fact the register. They're not internal spreadsheets, as my learned friend is going to tell you. They are the register, and this is why we would need the list of companies who have registered leases with the properties with the RAW. I have extracted most of these leases. Kindly ask you send this information in an Excel format. Any additional information such as ROC reference or rent term would be great. So when an internal memorandum was sent requesting the official registered leases data held by the RAW himself went to DIFC Registry Services and got it. And when he did that 1 year after this lease registration form had been signed, he found our data exactly the same, recording the 10-year lease. I think that's, unless there's any questions about that, I'm back to my I'm back to B15, Justice Giles, and we're heading down to paragraph 36, which is under the heading, still under registration of the lease.
There is a question, Mr. Ford, if you don't mind, not as to what you've just been submitting to us, but something that it sparked. You said that because of a dispute with DIFC Properties, UP didn't actually get title until sometime later. Now, what that raised in my mind is a question of what transfers of freehold were registered and when. Because if UP didn't actually get the freehold until sometime later, what was being transferred when you say that there was a transfer from UP to Emirates of the freehold. And I looked at the reference which you gave me, and it doesn't answer that question.
No. I might have to come back to you on that. I know that it's written in the that December 18, 2011 offer for sale and purchase. There is a reference in there to UP having the ability to sell off the plans, the documents, so being able to sell the properties prior to obtaining title from DIFC Investments. And I recall, sir, that it said that they were able to sell, that the 2 transfers were allowed under the agreement, so that they had an agreement, an inchoate agreement to be able to sell these properties. And it appears...
I'm not interested in what was agreed between the seller and purchaser. I'm interested in the registration.
Yeah, I know.
In the context we are talking, the register is all important, and I want to know what the evidence tells us as to what the register shows.
Right.
Well, it may be that there indeed was not even a register in these days, and that's why the...
Well, I say, sir, that there was a register.
What does the evidence tell us?
The evidence tells us that there was a register, and we've just been looking at it. So the RORP had said it in a letter that at that time the register was kept on an Excel spreadsheet, and the form of the register.
That's submission, then I understand it, but the evidence is limited to the spreadsheet. In other words, there is no evidence by way of a copy of instruments of transfer.
Yep.
In other words, there is no instrument of transfer from UP to Emirates in evidence, or from Emirates to Zain.
I don't believe, sir, that we were ever given that under document production. No, sir.
Well,
no.
You could have got. Could you not have got it by asking the registrar?
We've made a number.
Being essential to the conduct of any registered title system.
They did. I think the registrar said there was no record, and that's why the judge at first instance wrote to the registrar, I think, and there was some answer coming from the registrar saying there was no registration, if I remember correctly.
That may be so, but I'm just asking Mr. Forward. The position is that there is no evidence of instruments of transfer of the freehold. Is that correct? I'm
going to say yes, sir, and come back to you. I have thousands of pages of documents here, but none is springing to mind. That's correct.
All right.
The evidence which we have is the ones right at the end of the Nuran Al Maklafi exhibit, sir, which is the title deeds and the report. What do you call that report, sir?
Yeah.
That report that they provide.
Mr. Bowden.
Yes.
Mr. Bowden.
Yes, sir.
You're from Australia. You're from New Zealand, aren't you?
I am, sir. Yes.
And New Zealand has a torrent system as well?
Yes, it does, sir.
Torrent system of registration?
Yes, it does.
So does Malaysia. Indeed. And of course Australia.
Yes.
So I think Justice Giles' question is very pertinent, because normally, I don't know what's the practice in Australia, in New Zealand, but in Malaysia, there is a memorandum of transfer that we call, that both parties sign and register. And the registrar, your own argument to say that the registration in the Register of Titles is indivisible, but there must be a registration first. You have not shown registration. You showed evidence of intention to sell, intention to lease, but is there a registration of the lease itself being registered with the registrar of titles?
Well, okay. On the bigger picture, sir, at the time of the sale in January of the freehold, they registered at that stage. They registered caveats. I know that not because I have a copy of the instrument, but because we have the evidence of them paying the caveat fees. So Emirates caveated the property in January and released the caveats in March when the title was transferred to them. What the instrument of transfer looked like in March 2012, I honestly don't know. But if we go right to the very end of NAM 89, which I'm furiously scrolling down in the bundle, it's going to take a long time, the very last document, in fact, I'll give up that, but can I come back to it? Because I do go there right at the end of my submissions. And we can have a look at the document, which is NAM 89, which is a certificate of official search by the DIFC Registrar of Real Property. And that does records the caveats and the transfers on the 31st of March 2012. So we don't have the instrument, but we do have proof.
Who entered the caveats?
Emirates put caveats on.
Oh, you didn't enter caveats. Your client didn't enter any caveats.
No, sir. No, we didn't.
Mm-hmm.
Just to be clear, they're not caveats in relation to the lease. What my learned friend is saying is that there was caveats in relation to the purchase of the property. So there were never any caveats entered onto the register in relation to the leases. Just to clarify that. I
agree with what my learned friend is saying. Yes, when Emirates purchased the freehold of all of them, they and UP each paid half of the caveat fee, and they caveated all of these properties. And on the official transfer, because they paid in January, on the official transfer in March, those caveats were released. And that and the actual transfer in March 2012 is subsequently recorded in documents produced in 2015. Namely the search certificate, shows those transactions. It doesn't show this lease. And my submission is that the best evidence is that the register was indeed kept on these Excel spreadsheets. And the law says that the form of the register is a matter for the RORP's discretion. So he can keep it in any form that he likes. And that is the form that he chose. If it's not if it was a database, it would attach the registration, the actual instruments to it. And I'm assuming that somewhere in the RORP's record keeping, the instruments were filed away. The lease was there, so various things in relation to our transaction were there, and I'm assuming they were, and they were properly recorded.
I would like to ask another question, Mr. Bowden, a simple question. Under the laws of the IFC,
yes, sir.
What is the value of a lease if it is not registered? What is?
Yeah.
Because I assume there is no equitable lease under the IFC land laws. I'm just assuming because I do not know.
Great question. The answer to the first part, sir, is that every lease of more than 1 year's duration must be registered. Okay.
Okay.
Allied to that is Article, I'm pretty sure, 33, which says that an unregistered instrument is still effective between the parties. So it doesn't. So failure to register the lease doesn't invalidate it, right? But there is a requirement for registration and a fine on the landlord if you don't do it. And so the next point, as to the equitable interests of leases, equitable as
leases, equitable leases.
Equitable leases, yes. Article 31H of the former law, sir, the law we are concerned with, did allow for equity to intervene in leases. It needs to be said, sir, and I'm not sure if it's to do with this case or not, but that section has subsequently been repealed. So Article 31H, upon which we rely, which brings in equitable leases, and I've actually put an article in my about equity in Malaysian land law there on that exact point, sir. So equity can intervene in this lease under DIFC law under Article 31(H) of the law as it was. And that is, I noted with interest, one of the amendments or one of the changes in the new land law was that has now been repealed. So it was then no longer the case. I should be at paragraph 37, and most of which we've possibly answered. Okay, the legal effect of registration, the entire concept of indefeasibility, and it's the conclusive evidence on Article 29, means that registered instruments cannot be removed from the system except via established gateways. So the evidence is that the lease stayed registered until at least 2013, and we were just looking at this evidence a moment ago. We know that because on 15 July, Jabba al-Suwaidi, in respect of an unrelated query, asked DIFC Director of Registry Services for a copy. Okay, so we've looked at that. I'm sure you follow. What does a RORP say about registration? This is where it does get very interesting. At hearing, it was agreed that the court would write to the RORP and seek his view on the registration process and indeed what had become of the so-called provisional registration. Despite, well, I have a bit of a complaint here, sir. I put together a very detailed list of questions, and if yes, answer this, and if no, answer that. Unfortunately, that didn't go forward. A very quite a unsophisticated, open-ended sort of letter went forward. It didn't get the answers that it should have, and a better process should have been instituted. And I actually asked that the RORP attend for cross-examination on that letter because it's unsatisfactory in a number of ways. But, however, there are a number of things that are very important. Article 40. As a matter of law, the RORP was required to create folios and place within that folio the certificate of title which noted the registered instruments together with details of the instruments themselves. That is where the lease would usually be found. And I think that this comes back to your point, Justice Giles, that the RORP had to create a folio. And what the RORP says in his letter was, well, yes, I couldn't create a folio because of the underlying dispute over the building coverage. And so that is why I didn't do so. And that is why we created the Excel spreadsheets that we did. And my submission on that is, well, that is perfectly acceptable. It was a matter for the RORP how he kept the register. He kept them in a regular manner. They were kept by DIFC Registry Services and the record-keeping arm. And we say that what was done with the lease registration was perfectly regular. Because the argument came up, was it a provisional registration? My learned friend will like to tell you that this was a provisional registration, and that because it was a provisional registration, it wasn't a registration at all. We say, well, there's no such thing as provisional registration. And the only thing that could have made it provisional anyway was this building coverage issue. And the building coverage issue was resolved. And so therefore, if it was ever provisional, which we don't accept, it became full on the resolution of that issue. That's what we say. So I'm at 41. The RORP says in his letter that he was unable to create a folio because of the dispute between the developer and I've got DIFCA, but it's actually DIFCI, I apologise, over the coverage dimensions of the entire limestone house building. Okay, so under the master plan, they had 97% or whatever, and they went over it. That's a simple answer. The dispute had nothing to do with the VB lease. Whether or not the RORP, in the exercise of its discretion under Articles 38 and 39, and those deal with creation of folios, was prevented from creating folios is debatable. Nor does it matter, as the RORP's difficulties with the creation of folios may have delayed the issue of a certificate of title, but it had no impact on its ability to register instruments. Every unit in the entire building was affected by the building coverage issue, but those units were still purchased by Emirates on 31 March. Caveats were placed on, caveats were lifted, leases were registered, including the VB lease. The truth is that registration of anything was possible at any stage of the proceedings. NAM 20, which is printed off Mr. Baldwin's email letterhead, makes nonsense of any claim that titles, caveats, or anything else could not be registered in 2012. The master spreadsheets were used for exactly that purpose. And it might be useful, Justice Giles, if you wish to actually have a look at this email dated in 2012, and it's an HD 685, so it's in D1, page 685, and we down at the bottom of the page, and it said here, attached as a document dated 19 January 2012, so just in the middle of the sale process, from UP to Melanie Fernandez, copying Ali Al-Khatib, and he is the CEO of the company. The disclosed emails in PDF format, marked, okay, and it says, summary below of the DIFC registration fee for Index. They have been segregated based upon the agreement between UP and ENBB to share the costs equally, and a detailed report for each unit for both Index and limestone houses being attached for ease of reference. So that document set out, and we've only set out here, so the extract which affects our units, but it says 17A and 17B. That actually, where I've put red, that's me putting it in red, but it says leased underneath it. Says, and it shows the caveat fee and the registration fee being applied. And this, so for every unit that was sold, the parties paid and shared the costs of registration and the cost of caveats, and divvied them up that way. Would it be helpful to have a look at the actual document, sir? Or is the point?
No, I understand what you said. For me, no, thank you. Others may.
Yeah, it's okay.
Well, you may not like the imprecision, sir, but the proof is in the pudding, because this is what did happen. And no, we haven't. I've checked, and we have not been provided with those instruments for the underlying title. Paragraph 43. So I'm going back to paragraph 43, Justice Giles. Right, 44. Assuming that it was only once the building coverage dispute was resolved that the process of issuing titles could begin, the RORP's evidence is that the strata title plan was not presented for registration until 14 January 2014 and only accepted for registration on 16 January 2014. So this building, sirs, was surveyed, as we know, in February of 2012. And that survey was carried out with the intention of using the strata title law to create strata title plans. The strata title law is specifically subject to this law. So they needed to sort out their land title issues before they could create the strata titles. And that, it appears, is what delayed the issue of those titles. So, the lease, I'm at 45, the lease was not so lucky. The RORP explains exactly why when it says this. Consequently, in reliance of communications from the owner, Emirates MBD Properties, with DIFC Registry Services, dating back to December 2012, indicating that the relevant units were not subject to a lease agreement, thereby superseding the details of the 28 May 2012 registration. The folios in respect of the relevant units, when they were eventually created in 2014, did not record the relevant units. So what the RORP is saying, as I understand it, is that when I created the titles, which we see at NAM 88 and 89, when I created those, NAM 75, 76, and 89, when those were created, I did not put the lease on them because Emirates told me that the units were not subject to a lease, i.e. I didn't put them on the title because I was told there was no lease. Now, and we should move on to examine that. So, what does Emirates say about registration? Emirates has significantly altered its position. It's abandoned its initial position that the lease registration was a forgery. It's learned that DIFC strata title law is subservient to the DIFC law of real property. It's an entirely incorrect submission that the lease could not be registered until the strata title plan was registered is now evaporated. It's quietly shelved its headline claim that the units could not be registered as they did not exist as distinct legal property. We know that they did. This submission, unsupported by any evidence or authority and contrary to the applicable law, effectively won it the case. So it was saying to the court, my learned friend was saying to the court below that this unit did not exist as distinct legal property. There was nothing that enabled the registration of it. He completely overlooked those plans that we have seen. But when we drew them to the attention of the court, somehow the judge managed to overlook them as well. Emirates continues to disparage the registration process. It refers to the register as an internal spreadsheet, and not even the RORP says that. Instead, pointing out that the spreadsheet was kept by DIFC Registry Services, who the RORP says in his letter, sir, serves both the offices of the Registrar of Companies and the RORP. So the register was an official record. B, stating that the lease registration form was signed by Miss Melanie Fernandez, an employee of Emirates at the time. This tries to disparage her role. She was the senior manager in charge of the sale. She wrote the offer letter. She organised every aspect of the sale, and she organised every aspect of the lease. She signed the lease registration form. And then subsequently saying that it is intended to suggest that this was a matter of little consequence and to support the equally erroneous suggestions that the rent receipt was an accounting error. Now, honestly, it's for Mr. Montague Smith to explain that, but there is zero evidence of this accounting error. Rather, Ms. Fernandez was and still is a senior manager of Emirates who organised the sale, made the final offer, signed the transfers, was last in possession of the master sales purchase agreement, signed the lease registration form, provided the notice of atonement, receipted the rent, orchestrated the frauds, and was incredibly given the responsibility of searching her own emails, the key documents of which is missing. She is a witness whom Emirates have refused to present, instead inappropriately relying on the hearsay evidence of lawyers and the inappropriate submissions of counsel to shield her from the consequences of giving proper evidence. Okay.
Mr. Bowden.
Yes.
Has Justice Rogers, do you have some question to ask? No, Justice Charles?
My question is that Mr. Bowden should withdraw what he last said, which is not proper advocacy.
I'm sorry, sir.
Yes.
For him to do so.
I certainly do, sir. I certainly
Thank
do.
Okay. No, I was just going to ask how long more are you going to take? What you are doing to us, I didn't want to stop you for 2 hours. You're just reading through your submission, which
Yes,
all of us have in fact read through. So
Yes.
I didn't want to stop that because you said, but I thought you would just highlight, stress as you go along rather than read word for word. And please try to avoid, try to be more courteous and be more professional when you address people and things like that, Yes.
You're meaning that last paragraph which I just read?
Yes.
Well, yes, sir. Well, can we go on and look at the evidence, which I say, because I'm not seeking judgment on fraud here, but I am seeking leave to amend the claim to bring a claim of fraud. That is what I am seeking to do. So I'm not saying, and I appreciate Justice Giles's point, and I shouldn't have written it in the way that I did. But there is good, tenable evidence of a fraud here, and may we go and have a look at it? If I come down, sir, to, well, the first thing we need to come to, sir, is this. Emirates' admission that the lease is binding, because at heart, a lease is a contract. Registration is conclusive but not exclusive evidence of the registered interest. Between two parties bound together by contract, it's not necessary to prove registration. It was contended by the court that this was the effect of provisional registration, a practical means of keeping a record of a lease having been entered into in the jurisdiction of the DIFC, that a particular entity had entered into a lease for a property in the DIFC, which is generally a prerequisite for the issuing of a trade license in the DIFC under DIFC companies law. So what the RORP says about the effect of registration in my submission proves our case in contract, that there was a lease and that it was registered, and that it was for 10 years. So if we come down to Emirates agrees, the so-called provisional registration of the lease was simply a system by which a record of leases was kept to allow companies to satisfy the requirement that they have a DIFC lease. Absent some formal record of a DIFC lease, companies would be unable to obtain or renew their trade license. So with respect, sir, Emirates agreed during the hearing process that there was a formal record of a DIFC lease, and that could only be the lease which they consented to the registration of on the 28th of May 2012. And I say, sir, that that statement alone establishes Vegie Bar's case. Emirates agreed that Vegie Bar had a lease with Emirates. Now, the three
Mr. Bowden, if I keep my own internal records,
yes, sir.
I have my spreadsheet and I have whatever I want to record there. How could you hold me, you as an outsider, come and look at my records and hold me liable to you because what I keep in my spreadsheet? I mean, it may show my intention.
Yeah.
But it doesn't, you cannot bind me to you merely because what I state in my own records. I can write anything I like. I may have intended, my projection is this, that's why I put my spreadsheet.
Sure.
But it is not a contract. Contract, offer, acceptance, consideration.
Yes.
Where is the offer? Where is the contract? Where is the lease? Where is the lease? Where is the contract? The lease. There must be a contract. There must be some agreement between you and Emirates. Where is it? Where is it? Not registered. There was some intention. All the payments were made before the transfer. That's why I was looking at the figures. I was tracking the chronology or the chronology of the dates to try and fit where, you know, but I can't.
Can we step back through that?
Yes.
You're keeping internal records. If you and I, on the basis of your internal records, go to the Registrar of Real Property, taking with us a copy of the lease, and fill out all of the relevant details of that lease on the lease registration form. You sign it, I sign it, you stamp it, I stamp it. We pay the fee for registration. It goes to the Registrar of Real Properties. He signs, he receipts the fee, and he enters it onto the register. Surely, sir, yes, we have created a binding contract.
Yeah, but there is but you told us there was no registration of the lease.
Sorry, sir?
If there is a registration of the lease between you and Emirates, it's a closed, open and shut case.
Yes.
But is there a registration? There is a lease registration between you and. Can you produce the lease? The registration of lease?
We've got the lease, sir.
Registration between you and Emirates.
Yes.
I'm not talking about UP.
Yes, what happened on the 28th of May, sir, was between Vegie Bar and Emirates. It was. So yes, sir. And the lease which is described in that lease registration form is the same lease that they entered into with UP. So it is, if you like, novated across. It is effective, sir. Because, yes, Emirates did sign it. They did consent to it.
Okay. If that's true, why do you keep on relying on your spreadsheet?
Well, if
why are you still relying on your spreadsheet? If I have a lease, I produce the lease. Full stop.
Here's the lease. Yes, we've got the lease, sir. The actual copy of the lease. What page is it on? The actual lease document itself. The lease agreement. That's the If we go, I'll take you to it, sir. K1. We go to document K1. There. And I accept, sir, that it was entered into between Union Properties and Vegie Bar. I accept that. And there is no... Yeah, but sir, everything...
I'm asking Vegie Bar and Emirates.
Yeah.
I've been asking that. This one we recognize. Now you're talking about assignment. That's why you go at length, trying to say that this has now been assigned to Emirates. That is the argument, whether there was a genuine assignment or not. And my question to you was there a lease between you and Emirates? You say, yes, this is not a lease between you and Emirates. This is between you and Union Properties.
Okay.
Because you have this and you produce that, you're trying to show evidence from the spreadsheet, from to show there was an intention, perhaps of Emirates entering into a lease with you, but there is no lease.
Okay.
Right?
My
That's why
apologies.
you're talking about breach of contract, fraud, equitable lease, and things like that.
Yes. Well, indeed, sir. Because look.
No,
I
I'm just correcting.
apologise
I'm
if
correcting
I
your
was
statement. I'm
imprecise in
correcting your
language.
statement.
What I am saying is that this lease that we are looking at is the lease that was agreed to be carried on between Emirates and Vegie. That is the lease which they registered. That is the lease which Vegie paid rent on and which Emirates took and kept. And so was there a necessity for them to redraft a completely new lease? Well, the answer, sir, must be no.
My
Surely
question,
no.
my question, under the Dubai law, under the DIFC law,
Sir.
under the DIFC law, is you said if the lease is for more than 1 year, it must be registered.
Correct.
If you don't register, you said to me, I don't know how to, I've got to read the law. If you said that if it is not registered, then the owner is penalized for some reason. But you also said that even though it's not registered, the lease is valid. I've got to check the law because the way I understand that, if you're in Malaysia, if it's not registered, it's not valid. Full stop. You know. So I have to check that. But you say that it was if it is more than 1 year, you have to register. And here you cannot produce a registered lease between you and Emirates. You don't have that.
Well,
And so I go and start from the beginning. What was your course of action?
Well, Mr. Boylan, if
What
I
was your
might,
course of action?
CJ, Mr. Boylan, if I might intervene here, I think Mr. Boylan, you says Emirates' action by recognizing the UP, the contract, the rent contract between you and UB, and attempt to register the same contract before the DIFC registrar of property is a sort of recognition and accepting transfer of liability.
yes.
Is that what you're trying to say?
Yes, absolutely, I say that, sir. Yes.
Yes,
Yes.
thank you.
Other than to say, I say that the lease registration was effective, right? Those spreadsheets, right, that are kept by DIFC Registry Services, that was the register at that time. That's how they were doing it. And it was acceptable. We received, sir, a copy of the lease from the registrar of companies, an initial discovery. So we know that lease, same lease, was put into the system pursuant to this registration. So that is the lease, Chief Justice, that they went down and registered. They registered the novated assigned lease, the agreement, the lease which they had agreed with.
Do you have a special form to register the lease with the land authorities in the IFC?
Yes.
Is there a form that you fill in?
Yes. And
yes,
we
isn't it?
Sir.
Because in Malaysia, we have a memorandum of transfer. We have all sorts of forms attached to the National Land Code. So you fill in the form, you file with the registrar of titles, and the registrar of title will record that, and anybody can go and search the titles. But have you done that with this particular so-called lease? No.
Yes, indeed, sir. Yes. And
we are not talking about spreadsheet. We are not talking about spreadsheet.
No,
spreadsheet is something which. Okay, what is this? You showed this to us.
Yeah, exactly. Here it is. This is it.
What is this?
This is the registry. This is the form that they all signed on the 28th of May 2012 to register that
register. This is the form.
This is it.
To register,
Lease
signed by Emirates and then
Yes.
Ibn. I see. Is this the same one that you had with Union Properties? No, this is different, is it?
The same lease. Yep. There's only one lease, sir, and Union Properties names on it, and Vegie Bar's names on it. There's no lease. I agree.
But signed by Emirates. Signed by Emirates.
There's no formal
signed
lease.
by Emirates there. You see at the top there is signed by Emirates.
Yeah. So
it's signed by Emirates.
Yeah. I'm sorry.
So you are saying now, how can Emirates deny there was a proper assignment by them to you?
Sure.
This is your evidence.
This is my best case. I agree. It's a good one.
But why do you go and talk about spreadsheets for?
Okay, it's what happened. It's what happened.
Never mind. Go ahead. I don't want to interfere with your way of submission.
Well, I very much regret that I haven't been clear enough in what I'm saying. Okay, there's two types of spreadsheets. Okay, one is their internal spreadsheets, what I've called the master spreadsheet, where started by Union Properties, transferred to Emirates, and that's the one where there's 36 different versions, okay? And they kept their own records, including all of the details of the lease on those spreadsheets, okay? And we've looked at those. After the property had been sold on the 28th of May 2012, right, they agreed, and they, meaning Emirates and Vegie Bar, agreed that they would register the lease. And this is the lease registration form, the official form that you fill out to do so with the Registrar of Real Property. They took it, they signed it. It's got the proper details of the lease here. That lease would have been attached to that, and we have received via document production from the Registrar of Companies a copy of the lease. So we know that it was in the system. And they've signed.
Wait. Before you go on to say, what is this exactly? What is this? Vegie Bar, Emirates MBD, and you mentioned this Suwaidi is the registrar for.
He is
for companies or for titles for properties.
He's for properties. Yep.
Properties, not for companies, huh?
No, for properties.
Yeah, sure.
Yep.
Where does it mention this is for the lease? This receipt that you're showing us now?
No. I'm showing you that form. Where does it mention it's for the lease?
Registry real property form. What else does it say? I can't read. Can you show the page, the proper page? I can't. Registry of real property. What does it say?
What does it say?
Lease registration. Oh, it says lease registration.
Registration. Yeah. This is the official document, and I'm sorry, it's the best copy we've got.
Applicant's name. Yeah, applicant's name, Union Property, deleted with ANBD.
Yeah. Filled out wrong, corrected that it's and signed. It's got and it has the details of the lease. Those are the unit numbers. Okay.
But if I'm not mistaken, I read somewhere that the registrar of land titles or whatever it is has said that this lease is not registered.
Well,
that is the problem. It is this form, but the I read somewhere, I think the judge wrote to the registrar, and the registrar said there was no registration.
Sure.
Shouldn't you have got a mandamus against the registrar to register it first?
Sorry, sir?
Get a mandamus against the registrar to say, well, you're not register. Once you get the mandamus to register, then you're home and dry.
He's refused.
Yeah, get a mandamus, I said.
Yeah, the Article 149 of the real property law allows effectively that. So yes, if what I want this court to do is to agree that we had a 10-year lease with Emirates MBD, the same lease that we started with Union Properties. And when I get that order, sir, that is exactly what I will do. I will go to the Registrar of Real Property and I will make an application under Article 149 of the law and say, could you please now enter this lease onto the register and correct the register in doing so. And so, yes, give effect to our lease. Correct, sir. We should get mandamus. And what the debate, sir, is what this means. And I say that it is conclusive because this document was presented for registration in registerable form. And the signature of the Registrar of Real Property proves that it was presented in registerable form. If a document is presented in registerable form, it must be registered. And this document, we say, clearly was registered, even though the register is...
Are you sure it was not withdrawn or something? Yeah.
And
okay.
All that's wrong, if you like, with this registration, sir, is that it's in a strange form, right? They were keeping it on a spreadsheet at the time. But you can write a check on the back of a cow, okay? And you can keep your register on an Excel spreadsheet. How the registrar keeps the register is a matter for him. And this is how he was doing it. And in fact, it wasn't just him. It was DIFC Registry Services. So it was the official record. And we say there's nothing wrong with that. And we say that it was registered, and this proves it. Yeah.
Yes, I think you go on.
Okay. And sorry about the misunderstanding about the lease. There's only one lease, and yeah, Emirates is not typed on it. And I apologise if I was saying one thing. I never meant to say anything.
Okay.
Okay. So if we just come back to how come it didn't end up on the certificate of title? Because that's really the key point here. And again, this comes down to the frauds. Now, I don't want judgment on fraud, but I want leave to bring a claim in relation to fraud, and it's fraud against the registrar. So we say, and it's the registrar who has told us that the reason why this is not on the register now is because Emirates told him that there was no lease. And we say that had to be wrong.
Can I interrupt, I'm sorry, Mr. Bowden, at this point to try and clarify something?
Yes, sir.
The documents have the, what's it called? Your proposed amended particulars of claim.
Yes, sir.
The judge had those before him.
Yes, sir.
They added some causes of action and added a cause of action against same. That was what you're wanting to do. The documents here seem to have some amendments in them.
Yes.
In red, is that correct?
Yes, that is correct, sir. Because what I'm talking about now...
Hang on, just...
Sorry, my apologies.
I'm seeking clarification, which may or may not lead to something. One of the amendments is in red to include the fourth cause of action against Emirates, fraud against the registrar, which is what sparked this off.
Yes, sir.
And there are some other ones, perhaps of less significance.
Yes, sir.
Now, I have a bit of a problem with that, I think, because this is an appeal, and we are considering whether or not the judge was right to refuse you leave to amend what you put before the judge. I don't think that we can pay regard to these new red additions, which includes the desired claim of fraud against the registrar.
Okay. What I say about that, sir, is that we didn't plead it then because what the registrar has said, right, turned up after the hearing. This was during the hearing process that the registrar has come out and said, and I read it to you before, sir, and I can read it again because it's down at paragraph 63. So
I'm sorry to stop you, but I don't care really, or at least I don't think it matters why you pleaded them. can I repeat, this is an appeal.
Yeah.
We are deciding whether the judge was wrong on the desired amendments asked of him. How can we refer to some further amendments?
Exercise your first instance jurisdiction, sir.
What jurisdiction is that?
The Court of Appeal has the jurisdiction of a first instance judge, so it can make any orders that a first instance judge can make, and it's desirable to make this order now. I mean, the evidence.
Appeal against the orders made. That includes the refusal to give you leave to amend in the way you then wanted. We do not take on new jobs at that point. You don't come up on appeal. This is standard stuff.
Well,
say I want to recast my case entirely again. Treat this as a first instance case. I do have.
Okay. It isn't. Well, the Court of. Well, can I ask you to look at this, sir? Because the reason why it's happened is the evidence, and I'm at paragraph 63 of my submissions.
Mr. Bowden, please. I am not interested, and I do go back to those words, in why, unless it is proper for us to go into this question. Yes. And that's what I'm raising with you first.
Well, with respect, sir, I say yes, it is proper, because this court can exercise all of the powers of a first instance judge. I was reading this recently. So the court has got the jurisdiction to do that. And this evidence wasn't brought at the first time. Sorry, this claim was not brought in the first instance because the evidence to support it wasn't there. And I can't go making claims that in respect of which the evidence is not there. But I'm saying, sir, that it is there now, and it arose during the hearing process. It seems to me to be a little artificial to say, well, you have to go all the way back to the beginning and make a further application to the first instance court to amend what is only a draft. It was only ever a draft. So I want to further amend a draft. With respect,
right. That's your explanation.
That's my explanation.
Go through with it and see where we end up and what my brothers think in the end. But I did want to hear you to justifying the indicated I thought was not possible.
Well, every court, sir, has a jurisdiction to regulate its own procedure, and this, as I say, sir, it's a draft. I want to further amend a draft. It does not, with respect, seem to me to be an impossible task to further amend a draft. I mean, even now, sir, there may be some consequential amendments to any pleading put forward. That's always the case, sir. It was only ever a draft, and this evidence came up during the hearing procedure. And I say, sir, it's pretty compelling. So I'm back at 63 of my submission, sir. Consequently, and I've repeated what the RORP has said for good measure. He says the reason why it's not on the titles when I created them is that they told me that there was no lease. Okay, and we've just looked with the Chief Justice at the evidence that there was a lease. Now, there was a discussion, and I won't go into it because I can see that time is nearly up. But there was a discussion in November 2012 where Emirates was asked for evidence of the registered leases which they had, and they were asked to send through a list of the registered leases, and whatever they sent through, it did not include the leases which are here. But this is what actually happened, sir. The next attempt was much more successful. The RORP tells us that following the transfer of the plot to UP on the 25th of August 2013, and this is this building coverage issue. So when UP sorted out their building coverage issue, they actually received the transfer of the plot on the 25th of August 2013. The folios for the relevant units were created on the 16th of January. NAM 37C is a copy of the master spreadsheets. This is that same spreadsheet we've seen 36 times, Chief Justice, and I'm going to go to it, if I may. In Emirates records, and here is what they had. I'm still in Ms. McClarthy's witness statement at paragraph 129, and at that stage they had the Emirates, sorry, the two subject leases in rows 20 and 21 of the spreadsheet. If we go to the spreadsheet, which I now am, at D2, and this is NAM 73C on page D1134, and here is the spreadsheet that they had at that time in 2014. And here, sir, you see down the left-hand side of the rows, it's the same spreadsheet, Chief Justice, but somebody's tidied it up. And it's been given a birthday. And here we have the row numbers, and here we have our units 20 at rows 20 and 21, R17A and R17B. The next thing that happens, and we'll just skip through this, but whilst this was going on, the defendant was trying to get hold of Emirates MBD and get his lease going. Okay. The next point is this, if I just come down. At this point in time, they are asked, "Dear Mr. Java, good afternoon. Please find attached leasing data for EMBD units as requested." So the Registrar of Real Property had written on 31 August 2014 and said, "Please send me a copy of your leasing data." And this is the thing. As we need to have your leasing data from leasing time to verify against our registered leases, okay? And this is what happened next. We're looking at the spreadsheet 5 pages up. Here's what they sent through, sir. If you see the rows down here, it goes 16, 17, 18, 19, 22. And we see R16A, 16B, 18. So R17 and 17A and 17B were left off this data sent through to the Registrar of Real Property. Okay. And then if we carry on down, we see the documents which were actually created. And here is a certificate of title created in November 2014. And then here we have a subsequent, because this is all in date order, we have here at R70, NAM 76, we have a later version of the same spreadsheet. And you see here, row 20 and row 21 are restored. So it was there in 2013. In August 2014, these rows disappear. And in 2015, we've got a copy of the same spreadsheet from the same set of records, and it's back. So only when they sent the records to the Registrar of Real Properties did they delete or hide these 2 rows of their master spreadsheet. And that told the Registrar of Real Property that there was no lease. And that is why when we come down to the final document, sorry, I'm just scrolling, which is the sorry, I'm going to have to go back to my submissions and back in. It's very annoying. Yeah, NAM 86, I'll try it.
If you're going to take some more time,
I'm very
I
close
want
to
to
finishing.
suggest. How long are we going to take?
I'm on the last few pages now of the
Okay.
case, sir.
After that, that's it. Is it?
Yeah, and then
Okay.
so sorry, the document I'm looking for is NAM 86. Sorry, NAM 89. I'm sorry, Sus. I'm trying. I have to go to the last number that I can possibly get to and scroll down a little bit to get to the actual document. My apologies. It's not going to take me long.
Who's occupying those two premises now?
I believe that they're still empty, sir.
Empty.
Yeah, I believe they're still empty. Here I am, sir. I apologise. This is the official search certificate, and this gives the record, sir, of for 17A in any event of the registered interests, and this shows as a registered interest. It shows the SPA between Union Properties and Emirates NBD, and it shows the sale date, and it shows the registration date here of the 29th of March, and then it shows the subsequent sale to Zane Capital. But it does not show the lease. And the reason, what we've just heard from the Registrar of Real Properties, is that the reason it's not there is because Emirates told him, as we've just seen, by hiding the rows, that there was no lease. I probably only have a few more minutes, sir. Do you wish to break for the lunch now, and I can finish?
No, if you're going to finish the next few minutes, we'll just let you finish first, Roger and Ali. Yeah, okay.
Thank
go
you.
ahead.
Yes.
Because it's dinner time for Roger and lunch for Ali, Judge Ali and Judge Rogers.
And breakfast for my learned friend.
Yes, breakfast for
Second breakfast.
Yeah. Okay.
Okay, I'm back to feed 15. And I just now want to, I take it that's clear. You understand what was done and what was said to be done. That the registrar asked for copies of the registered leases, and he was sent a spreadsheet with 2 rows removed. And that then subsequent versions have it put back. The equitable fraud. The equitable fraud is simple. There was a subsequent sale to Zane on the 6th of March 2016 that we've just been looking at. Okay, what the agreement says is unclear. However, this much is what we say. It is relevant that Zane is a related party to, it's called National Corporation for Hotels and Tourism, the operators of the Ritz-Carlton Hotel, same group of companies as Zane, who as common ground gave permission for VB to operate a bar and restaurant in the leased area. Contingent upon the equitable fraud being established, this claim allows for specific performance against Zane and an application to correct the register under Article 150 of the law. So what we say is that if Emirates sold the lease to Zane, sorry, my apologies, I need a break too. If Emirates sold the fee simple or the freehold to Zane without the benefit of the lease, knowing that there was a lease, that was what is known as an equitable fraud against Vegie Bar, i.e. it was an action taken to defeat their interest. It doesn't have to be the primary purpose. It can be a subsidiary purpose. It can be a collateral purpose. All it has to do is that if they knew that Vegie Bar had a lease and they sold the property without transferring the lease with it, that is the equitable fraud which we allege.
But what do you actually mean by equitable fraud, please?
By equitable fraud, sir, we mean it's not necessary that it was deliberate. It's just that if they knew that Vegie Bar had a lease and that they were bound, that they themselves were bound to Vegie Bar in terms of the lease because it was registered and because they accept that it was a formal record of a lease entered into. If they nevertheless then handed it on without looking after the interests of Vegie Bar, well, that, sir, is an equitable fraud.
I'm not really familiar with that notion of equitable fraud.
Okay.
Can you give an example in the authorities?
Yes, sir. I have set out here in the authorities. If we come here, this is, you may indeed be familiar with this gentleman, sir. Sorry, it's quite slow to go through, sir. What's fraud? There's a slide on it here which puts it very crisply, sir. There we go. There we go. And I do in fact have these authorities, sir, but I haven't put them in the bundle, but I can certainly upload them.
I actually have a lot of authorities that have been downloaded from the e-bundle. So what's the authority you're taking me to?
This is the authority, sir, this is the article by Associate Professor Cameron Stewart, as he then was, and it's a J14. And at internal page reference J1932.
Just give me a moment, if you would. Is that the article entitled Indefeasibility and Fraud?
Correct, sir.
And when I scroll, I've got what looks like sort of headings, really, more than a complete text.
Yes, exactly, sir.
Isn't that connected with the question of whether registration, whether taking a freehold free of an unregistered instrument can be overcome if you did so by fraud? Is that what you're about? Which is a concept that most Australian type systems, but not at this relevant time here. I think. In other words, it doesn't give you a cause of action in fraud.
Yeah.
If there is morally reprehensible conduct, which is the notion of fraud, in taking a title with something morally reprehensible, more than knowing that the unregistered interest exists, then you may nonetheless be subject to that unregistered interest.
Yes.
But that doesn't give a cause of action for anyone. All that does is enable one to say Zane takes subject to my interest, and that requires reprehensible conduct on the part of Zane. I don't quite see, if that's what we're talking about, I don't see where this notion of equitable fraud comes in. It's something quite different.
Okay, it's like this, sir. So if I have established, right, that Emirates were bound by the lease, if the foregoing has established that, and they knew it, when they sold to Zane, if they did not transfer the benefit and burden of the lease at the same time, right, they have acted in a morally reprehensible way and have not and have deprived Vegie of the benefit of the lease. They sold it to defeat the lease, sir.
You may not have heard me. The morally reprehensible person must be Zane. If the taker of the title,
if we
morally reprehensibly, he may be forced to recognise the interest of the unregistered interest holder. That's the concept.
And that is a different.
In other jurisdictions, which I don't think we do have the fraud exception here, though.
Yes,
I need to.
Yes, we do.
It is okay. Yes. All right. But does that not need the morally reprehensibleness, the fraud in the terms of the statute, most statutes, to be that of Zane in this case?
No, I do not believe it does, sir, because under Articles 149 and 150, right, if Zane took it, Zane would have indefeasibility in relation to the title, right, if they took it from Vegie from Emirates, okay, and there's no fraud alleged against Zane. There can't be. There's nothing to say that Zane acted to defeat the interests of Vegie. However, sir, Zane would be nevertheless subject to losing their registered interest under a correction of title action under Article 149 and 150 of the law, because, and solely because, through their relationship with NCT&H, a group company, they had originally consented to the lease, right? So that because of that, they would be susceptible, right, to an application to correct the register, and it wouldn't be necessary to prove fraud against them for that purpose. Okay. But as against...
Okay. We can forget the label of equitable fraud, can we?
Well, no, sir, because it still stands against Emirates MBD. It may be that because they have sold to Zane, and if Zane was a purchaser, a bona fide purchaser for fair value, it may be that wouldn't be that you couldn't attack the defeasibility of it or the indefeasibility. But it still means, sir, that they have committed an equitable fraud. Forget
they being who?
Emirates, sir.
Oh.
So it wouldn't necessarily lead to the title being changed. You see what I mean? So, but it is a freestanding cause of action. If they sold this property knowing that there was a valid lease in place, that itself is an equitable fraud. What flows from it?
Can you give me some authority for that? Can you give me some authority for that proposition?
Yes, I have, sir.
Because it's not Professor Cameron Smith's article.
Okay. I believe that those two cases that are mentioned in Cameron Smith's article, sir, are correct for that proposition. And if I can come back to you over the lunchtime, I'll grab them.
Yes, that would be fine. Are those cases in the list, or do you need to get
No,
them?
they're not. But I believe I've seen them before.
All right.
So that's the proposition.
The Chief Justice's agreement. Come back to that.
Yes.
After lunch.
Yes. Can you speed up? Well, you come back with the authorities later, but in the meantime, you bet. I think we should speed up because it's already 1 o'clock for you too.
There is this slight matter of the Registrar of Companies. The company has subsequently been struck off. Do you wish to hear about that?
You mean Vegie Bar has been struck off?
Yes, sir.
So where's the locus standi?
We have made an application to the Registrar of Companies for it to be restored, and that wasn't dealt with in the court below, or by the Registrar himself, sir. And we rely upon an undertaking given by the Registrar that this company could remain on the register until the end of this litigation. But unfortunately, that was not kept.
I may help to shortcut this. I've been through the materials that Mr. Bowden provided on this, and the company was struck off at an earlier time, and there was correspondence with the registrar who said, all right, I'll restore it to a position of a status of not renewed rather than struck off. He didn't, and there are a number of letters from Mr. Bowden saying, please do what you said you would do. He asked the trial judge to do something about it, but the trial judge refused, quite rightly, because there was no proper application before him. There is now an application filed in this appeal by a former officer of the company, who is one of the persons who can apply to have the company struck back on. Given the correspondence, it does seem to me that it's appropriate that the company be put back on. I see Mr. Montague-Smith is holding up a hand of some kind, so he may want to say something about that. Subject, however, to at the least proof that the gentleman who is the applicant is a former officer, because we don't have any proof of that. But that's what we're on about. Maybe since Mr. Montague-Smith seems to be wanting to say something about that, that's again something we need to defer until after we have had nourishment.
Yeah, good idea, Roger. Good idea.
I just have a very short observation in relation to that. It won't take long for me to make the point, but I'm happy to say it now, or I can wait until after lunch.
We'll do that after lunch. How long she will take? Because Roger, you need to have your dinner, and Ali has to do his prayers and lunch, and I don't know about Tom and Mr. Bowden. You are in London too.
I will say I'm finished. Thank you, sir.
Yeah, but how long?
I'm in your hands, Chief Justice. Perhaps we could make a slightly shorter lunch and come back at 2 p.m. Dubai.
2 p.m. Dubai. Now it's 1 p.m. Dubai, so we take a 50-minute break.
That's good for me.
50-minute break. So we come back at 6 p.m. Malaysian time, 2 p.m. Dubai, and what time is it in London?
That'll be 11 a.m. London.
11 a.m. London. Okay. Court adjourned until 2 p.m. Dubai time. Thank you very much. Okay then. Can continue then.
Thank you, Your Honour. Well, I'll get started on my submissions if I may. I should say I've left the window open.
I can't see you. Is that something wrong with yours or mine?
It might be wrong with mine. I can see myself. Am I invisible to everybody
Okay.
else as well?
Okay.
I
Yes, go
I
ahead,
can
please.
see Mr. Madhani Smith.
I can't see his face. I can hear him. Okay, Jama, go ahead.
Maybe
Just
if
go
you
ahead.
scroll across, that you've got
Yeah.
too many screens.
Maybe. Oh, yeah. Is it? No, yours in the middle of the screen. Okay, Jama, anyway, just go on.
Thank you very much. I should just say I've left a window open here. I'm hoping there won't be too much. I'm risking background noise, but if there is too much background noise, just let me know and I'll close
Okay.
it.
It's hot in
so
summer.
where I was
It's
going to start was,
hot in London. Okay, yes, please go on.
Oh,
Yeah,
it's more this
go on,
office,
go
I'm
on.
afraid.
Yeah.
So we know that the claimant entered into this lease over these 2 units in Limestone House in 2011, and it took the lease from the then owner, Union Properties. And then after that, Emirates purchased those 2 properties, those 2 units, in January 2012. And everybody agrees that the lease was not registered before Emirates purchased the property in January 2012. And everybody also agrees that notice of the lease existing would not be enough to cause that lease to be binding on Emirates. So there's a factual dispute about whether or not Emirates had actual notice of the lease, but it doesn't matter for the purposes of this application. So the central questions in this case that we're dealing with on this application arise out of the questions of, firstly, whether or not Emirates became bound by the lease, and secondly, if it would otherwise have been bound by the lease, the 2 defences that I raise. And those resolve into 5 points, which I'll explain. But there are a host of other points that are raised, like bias, for example, against the judge below. It doesn't appear to be seriously pursued. It wasn't mentioned in the submissions. But I'm going to focus on those 5 points. Everything really turns on the central issues of whether the lease became binding, and if it did, whether it's enforceable or otherwise valid. And so the first part of that resolves into 3 questions. Firstly, was there an agreement between the previous owner, that's Union Properties, and Emirates and the claimant for the novation of the lease from Union Properties to Emirates? It's put in terms of assignment, but we've seen where that went. So it's about novation. The second is about registration. Was the lease registered in 2012? And if so, what's the effect of that? And then the third point on this category is did Emirates become bound as the result of some equitable doctrine? Is there some equitable doctrine that applies here that caused the lease to be transferred or binding on Emirates? That's the first category. You've heard quite a lot about that from Mr. Bowden. But then there are 2 further points that are raised, which is firstly, is the lease void, or did it become void or otherwise unenforceable for illegality? And that arises because operation of bars and restaurants always was and still is prohibited in Limestone House. And that's by the terms of the Strata Management Statement, which is one of the constitutional documents for Limestone House and the properties. So that's the first part. I'll call that the first defence. And then the second defence is the lease void or is it unenforceable for uncertainty? Because in March 2011, I'll get the date, sorry, but subsequently after the lease was entered into, there was an agreement to vary the lease, and that was between the claimant and Union Properties. And we'll look at that variation, but what I say about it was that the effect of that was to put the lease on hold indefinitely, and such that the court cannot, there's no objective way that the court can find the start date for that lease. And so it has become uncertain, and I'll deal with that. Now, all of these issues arise in the context of applications and cross-applications between the parties that came before the judge below. And so what the claimant was seeking was an order permitting it to amend its then existing claim, and also for immediate judgment on parts of the claim that were being pursued. And then the defendant advanced a cross-application, resisted the application to amend, but then also applied for summary judgment or immediate judgment on the claim as it existed absent amendments. And so for the amendments, the claimant has the burden of showing that it has a real prospect of success. So it's for Mr. Bowden to persuade you that the judge got it all wrong, and in fact there was a real prospect of success on the claim that he amended. But the other requirement is that the proposed case for an amendment must be properly pleaded. It has to be set out in the pleadings. Now, in the interest of time, I'm not going to take you to the authorities for that, but the references are in my skeleton, but for your note, I'll give you them. The first is the Orion Holdings case, which is at Bundle L, tab 7, page 2396, paragraph 22. And that there is also that follows the English approach, which is recorded in the White Book, and you'll find the relevant part at Bundle L, tab 14, page 2545, and the relevant paragraph is 17.3.6. So that is what my own friend has to show the judge got wrong, that where it comes to his amendments, they were properly pleaded, and as pleaded they did have a real prospect of success. Just so you know where the claim was at, so you understand what the issue was for the judge, I'm just going to show you very briefly the claim as was advanced previously unamended, and that's in Bundle K, tab 4. And it's page 2137. And if you have that, the central paragraph is paragraph 8, which you find on 2138. So it says, firstly, paragraph 7, in March 2012, Union Properties sold the freehold of Limestone House to the defendant. Paragraph 8, the sale of the freehold interest in Limestone House by Union Properties to the defendant was expressly subject to and made with notice of the leasehold interest of the claimant as set out in the first further lease agreement. And then goes on to say, well, they tried to get access to the property and were refused. So that is the case as was being advanced. So that's the case that I have to show has no real prospect of success. And then when it's difficult to track the amendments that were actually being sought below because no marked up version was supplied to the judge. It said in my learned friend submissions that it was, but it wasn't. The actual version you would find it's in Bundle B, but what I'm going to work from is the one that we've been looking at earlier today, which also includes further amendments that Mr. Bowden wants to include. I'm not going to work from that because I don't accept that he should be entitled to pursue further amendments at this stage. He shouldn't. But I do it because partly he then deletes some of the amendments that he was seeking below, and so he must be taken to be abandoning that part at least of the proposed amended case. You will find that document in Bundle B behind tab 16. We don't need to go to it quite yet, but we will do in due course, because you haven't been shown what actually is pleaded. And there's a reason for that, because it's very, very narrow indeed. I'll come on then to deal with the 5 issues, if I may, but I just wanted to make a number of brief prefacing points, if I may. The first we've already touched on, which is that the appellant doesn't currently exist, and I've heard what His Honour Sir Roger Giles says about that. The only observation that I make is this is not just a technical point. Normally, if you want to restore a company to the register for the purpose of allowing it to pursue a claim, then the applicant, defendant, directors or shareholders, the interested officers or parties, would need to show that the proposed claim has a real prospect of success. And the effect of that's the same test, in effect, that you would have in these proceedings. And the effect of that is that it puts the directors on the hook for the costs of the exercise if the application fails. Because if this appeal fails, there's no point in a costs order. There's a small amount of costs that's obtained on account by way of security, but it won't cover the costs of this exercise. And so the defendant will be left with a costs order against the party that doesn't it exists or does exist but is insolvent and will be immediately struck off again. So applying the way that it did, we say would allow the directors to sidestep that. So the only observation I would make is that if the court is minded, as it sounds like it is, to order order the restoration of the claimant to the register, then it should simply leave open the question of whether or not the costs of this exercise can be subsumed into that application, if you see what I mean, and therefore brought to bear against the director and shareholder who's bringing that. I don't ask you to resolve that question today. We can have that argument later if we need be, but it's really a way of making sure that the door is not closed for my client to pursue the costs of this exercise against the directors or shareholders, if that is the right approach. That's the only observation I was going to make in relation to that. I don't get involved in that application otherwise. The second observation that I make is that this is a very stale claim indeed. We are arguing about a lease that was entered into between the claimant and Union Properties on the 5th of April 2011. That's 9.5 years ago. Emirates purchased those units in January 2012 and sold them in March 2016. And the proceedings were issued just before the sale but served just after. And they've been on foot by now for 4.5 years. Now, some of that delay is the result of various trips to the Court of Appeal, and obviously COVID has intervened as well. But there is delay that has been entirely unexplained, and there was below as well. And in particular, the claim had come before the Court of Appeal in early 2018 on the defendant's application for security for costs. And the Court of Appeal had issued its order in January, dismissed the claimant's appeal against that order, but ordered the defendant to make English-style disclosure at that stage. And that was provided in February. And then it was not until November that the claimant issued the applications which led to the hearing below, to amend the claim and for further disclosure. And so most of 2018 was lost for unexplained reasons. Now, I say this is relevant. The appeal and the hearing below should be seen in that context, because the application below, as I've said, was for an order permitting certain amendments to the statement of claim. And the judge is criticised for not taking into account allegations and material which is not relied on and doesn't support the draft pleading. So, for example, you've heard a lot about this complaint that the judge should have found that there was a master sales agreement which covered the units. That's not something that's even pleaded. We see this allegation about the defendants collecting rent, as it's put. That's not pleaded. That's not accepted either. And then you've also heard 3 new, and I say contradictory, theories as to why a new lease might have arisen as a result of from various other conducts. So firstly from the collection of rent, secondly from this so-called notice of atonement, and thirdly from the signature of the registration document for the lease. None of that appears in the draft pleadings either. And when we come to look at actually what is in the draft amendment, we see that the case advance is very similar to what was put in the claim form, and it's based almost entirely on the allegation that the defendant knew of the lease when it purchased the properties, and that is not, well, first it's not accepted, but even if it was made out, even the claimant now accepts that that's not enough to cause the lease to bind the defendant. So what I say about this is that given the history, the judge was perfectly entitled, and we would say absolutely right, to confine himself to the proposed amendments that were actually being sought. This wasn't an extended 2-day drafting session. The claimant should have set out its case in writing and asked the judge precisely what it wanted. And as we've seen, even now the claimant wants to add further bits. But even when you look at what's proposed now, we say the real problems with the claim are simply not addressed. And the stage these proceedings have reached is also relevant in another way, because the extent to which the judge goes into the evidence on an application of this sort is a matter of his discretion. So it's perfectly open to the judge, and again, I say absolutely right for him to grasp the nettle in a case like this, in light of the history, and say realistically, now that we've had all of this disclosure, what is the position going to be at trial? Is there a real prospect of the claimant establishing its case? And if it does, will that lead to a finding in its favour? Now that second point then is reinforced by a third point, which is that there is little chance that there is any value in this claim, and that's a point that the judge made. The claim is for the defendant's failure to honour the terms of a lease. And the claimant's case in that regard is frankly incoherent. So it seeks damages, but it doesn't set out any case as to what it has lost. It says it can't do so. But all the relevant facts for that exercise are in its hands. There's no information that the defendant can give which would shed light on whether the claimant would have made a profit, for example, from running these these units as a restaurant. And normally, you'd expect a party to find another place to set up their business and claim the difference in rent. But that isn't the way that the claim is put either. And there was some evidence below as to the current status, and we had some photographs in the bundle. Again, in the interest of time, I won't take you to them, but the evidence was that there are 27 units in this whole area. Of that, the maximum occupancy that there had ever been was 7 units occupied. At the last count, there were only 4. So this was not a thriving hub of commerce. It's not a particularly special location. It's not said that the rent was below market, and the defendant simply the claimant simply chosen not to explain what loss it has said to have suffered. But there's a further fundamental confusion in the claim, because in the case as previously alleged was that the lease had not yet commenced, and the remedy that is currently sought is still consistent with that position. If you turn up B16 and go down to page 291, you see the remedy that is sought is there in the prayer, wherefore the claimant claims against the second defendant. If you look at B and C, please. What's sought is an order that the further lease period be amended to a period of 10 years from the date of judgment, or a later date to be determined in the judgment, and an order that the second defendant make the leased unit available for a period of 10 years from the date to be determined by the court. So what's being said is it should be entitled effectively to have a lease going forward from judgment. And now that's actually the latest proposed amendment, the one that's new in this appeal, actually seeks to say, well, in fact, the lease commenced in November 2012. And you see that if you go back to page 282 of this, and you will see then 32B, you'll see the extension of time for the commencement of the further lease bound the lessor to make the premises available to the claimant. And there's 2 proposed alternatives, but B is when the claimant requested access to the property from November 2012, something the first defendant reasonably refused to do. So as I understand that, what's being said is that the lease commenced in November 2012. And just sticking with this point about the value of the claim, throughout this time, and I'll show you this in due course, operation of bars and restaurants in any of this space has been prohibited. So what I say, the quantum here is unpleaded. The case is incoherent in relation to when the lease commenced, and the clear likelihood is there could be no loss, even if the claim succeeded. So again, this is relevant to the judge's exercise of his discretion as to how deeply he went into the evidence to determine whether there was a real prospect of success. And also how much latitude should be given to the claimant in its pleadings. And the final point is the question of disclosure. Mr. Bowden makes great play of this, but his complaints are, in my submission, wholly overblown. So what happened is this. Let me just explain it to you. It is right that something went wrong with disclosure, but it's not as dramatic as Mr. Bowden makes out. The defendant, the Emirates, was ordered to give English-style disclosure, as I've said, and that order was made on the 24th of January 2018. For your note, that is A1, tab 1, page 2, paragraph 3 of the order. It was given a relatively short amount of time to do that, and it gave disclosure on the 28th of February. And you have in the bundle a disclosure statement and a couple of further witness statements that have come through, and I'll take you to some of it, because this is a criticism of my client. Now, doing this disclosure exercise was a significant exercise. And the way it worked was that various custodians of documents, digital documents, were identified, and their archived data for the relevant period was collected, or harvested as it's put. And that process by itself took 19 of the 35 days that were given. And the reference to that is bundle K, tab 8, page 2172, paragraph 6. And then, so once that data had been collected, it was searched using keywords, and the documents were produced. Now, as I've said, the claimant eventually made its application below, which included disclosure application. And the particular requests that were made were addressed on behalf of Emirates by Mr. Hadi Brocklehurst in a witness statement, and you will see that at E5-1452. Might just be worth having a quick look at that. And the relevant paragraph is paragraph 5. And so he explains what has been done in relation to this. Now, in this process, what happened was Emirates realized that there were relatively few emails in Ms. Fernandez's email folders for the years 2012 and 2013. And it turned out that what had happened was that there had been an IT error in harvesting her emails. So it wasn't at the search stage, it was at the collection of the data stage. It was an IT error. This is explained by Mr. Barrick in his witness statement at tab 7 of the same bundle, tab E7. And so what he says is that once that had been recognized, then the further documents were harvested and the exercise was redone and further searches were carried out. So this is not some great conspiracy. It's an error that occurred at the IT level. It was picked up by Emirates itself and immediately disclosed, and it was then corrected without anyone ordering it to do so. So the defendant apologized below for the error, and I apologize again to the Court of Appeal on behalf of Emirates, but it is quite wrong for this to be elevated into some sort of allegation that Emirates is deliberately suppressing documents. If that was its strategy, the court would never have known about this. The error is regrettable, and it's been detected, owned up to, but since then Emirates has been scrupulous in bringing it to the attention of the court and correcting it. It's also, by the way, just simply wrong to say that Ms. Fernandez was in charge of the search for the master sale agreement. It's also wrong to say that I promised further disclosure at the hearing. But quite a lot of emphasis was placed on that in suggesting there must be more, there must be something more in documentation. But a thorough search and a thorough disclosure process has now been undertaken, far wider than the normal disclosure process that would be undertaken in a claim in this court at this stage. The court would not normally order English-style disclosure of all documents, even those which don't support the case. They would normally allow for interrogatory requests. Those are the prefacing marks that I wanted to say, and with that I was going to move on and deal with the 5 core issues. Firstly then, dealing with this question of, as it was put, assignment, but it seems to be novation is the way that it needs to be put. Now the court knows that the DIFC law of real property is based on the Torrens system. So the starting point in DIFC law is the indefeasibility of title, which means that if it's not on the register, then there's no interest in land, no in rem rights. So a purchaser, the effect of that is a purchaser can check the register to see what interests affect the land, and then once he purchases the land, he takes the land free of any unregistered interest. There are exceptions to that, and I'll come on to those. But if the register is clear, the starting point is that the purchaser gets clear title. And as I say, there are exceptions, one of which is this equitable exception, and we'll deal with that. But none of those can be interpreted in a way which undermines the principle, which is the core principle, what's been described as the hallowed principle of the Torrens system, that it is not enough that the incoming owner knows about an unregistered interest. That's not enough to bind him to that interest. Now, I won't take you to the authorities in relation to that. They're set out in the skeleton argument. There is also an article by Dr. Arietta Sevilla, which is quite useful. Again, I won't go to that. But one way of thinking about it, which he uses, which I find helpful, is he explains the differences between this system and, say, the English system as a choice between protecting, on the one hand, the party with the unregistered interest using liability rules, and on the other hand, protecting him with property rules. So if you take the position of the party who has a valid and binding lease, but it's unregistered, they have contractual rights against their landlord. And if the landlord sells to another party, then English law protects the leaseholder by making sure that the property rights go with the land. So the leasehold interest goes with the land, subject, of course, to exceptions, and the major exception is equities darling. And you can't be equities darling if you know about the lease. And so if you know about the lease, you become bound by the lease. So the leaseholder gets a claim against the new owner. That's the English approach. Now, under the Torrens system, under the DIFC system, it's the other way round. The leaseholder is protected with liability rights, not property rights. So he loses his interest in the land, it's destroyed forever, but he is protected with a claim against the original outgoing landlord, liability rights. And if something's gone wrong with the registration process itself, then you may have a right to be compensated by the registrar, and there's a system of indemnification, and that's usually where the registration fees go. And there are policy advantages to this, primarily cost, speed, purchaser confidence. So that's the in-rem part of it. That's the in-rem aspect, and that's really where the Torrens system is different. Now, the other way you might be bound is personally to a contract. The lease may be novated to the new owner. And it's just worth seeing that in the real property law, which you'll find in Bundle I, which is just the real property law. And if you go down, please, to page 9 of that document, it's 1694 of the bundle. You'll start Article 25, which is the provision about conclusive evidence of information in the register. 26, subject to this law, an instrument does not transfer or create an interest in real property until the instrument is registered. So there's no interest in the property at all until the instrument is registered. No in-rem rights until then. But then if we go down to Article 33.1, which is on page 1697 of the bundle, you get the contractual preservation of contractual rights. Nothing in this law prevents an unregistered instrument from operating as a contract or being otherwise enforceable according to its terms. So that's the distinction. An unregistered lease doesn't create an interest in land. Subject to these exceptions, it won't bind the incoming owner, but it may operate as a contract, and obviously, therefore, if that contract is novated across to a new party, then it might bind them in contract too. So that's the distinction between the in-rem rights and the contractual rights, the in personam rights, and they are distinct. And this is important for another reason, because, as I've said, the contract itself does not create an interest in the land, but by the same token, registration does not, which does create an interest or can create an interest, does not create a contract. All right, but I'll come back to that when I deal with the registration issue. So the first case is that there's been this novation. So what you are looking for a novation is a contractual agreement between Union Properties, Emirates, and the claimant to novate the lease from Union Properties to Emirates. And this case has substantially changed from the proposed amended pleading to the case that was put in argument below and to the case that was put in argument today. And we do have to look at the pleading, because by now in this case, the pleading ought to be in the form that it is sought. And when you ask yourself, did the judge get it wrong? You have to ask yourself, should the judge have allowed the amendment that was sought? So the pleading in relation to this, you'll find at Bundle B, tab 16. And again, I'm working from the most recent version, but we can see which bits are brand new for this appeal. But the amendment that was being sought is at paragraph, if we go to page 280 of the bundle, it starts at paragraph 22, which is the bottom. So 22 says, by agreement for sale and purchase dated on or about 11th of January 2012, Union Properties agreed to sell its remaining units, including the leased units in Limestone House DIFC. And then on or about 29 March, Union Properties transferred the freehold of the leased units to the first defendant. paragraph 24, the first defendant was aware prior to its purchase that the leased units were leased to the claimant pursuant to the further lease. It says knowledge is pleaded there. And 25, the sale of the freehold interest in Limestone House by Union Properties to the first defendant was therefore expressly subject to and made with notice of the leasehold interest of the claimant as set out in the further lease. So the pleading is that the sale took place on or about 11th of January 2012. Defendant knew about the lease when it purchased, and therefore the purchase was subject to the lease. Now, that is an argument which, if established on the facts, would have worked in England, but it doesn't work in the DIFC. And if you actually, because knowledge isn't sufficient, and everybody now accepts that. Now, if we actually look at the sale and purchase agreements themselves, they say quite the opposite to what's being pleaded here. So we find those sale and purchase agreements in bundle D at tab 3, and it's the first page of tab 3, page 1220. This is for unit 17A. There is an identical, substantially identical agreement in relation to 17B as well, which is at 1259, but we don't need to look at them both. So you'll see, if you go forward 2 pages, at 1222, you'll see this is the 11th of January 2012 document, which is the sale and purchase agreement that's being alleged. While we're here, just to pick up on this point that was made, it was said that the sale and purchase agreement did not provide individually for payments to be made in relation to these units. Now, I'm not quite sure what's meant by that, but if you look over on page 1223, you will see that there was a distinct purchase price for each of these units. It's blacked out here. I think we did have an unredacted one below as well, but in any event, if the submission is there was no distinct price for each of these units, that is wrong. There was. So now, if we go forward, and you were taken to one of the clauses I rely on and told that that was the only thing I relied on. It isn't. But if we go forward, please, to page 1231, you'll find clause 4.1a, transfer of title, and then various provisos, but then it says, on those provisos being satisfied, possession and occupation of the unit, of the property, shall be given to the purchaser, and all risk in and benefit in respect of the property shall pass to the purchaser. Now it's said, well, risk and benefit somehow mean that carries the lease with it, but risk and benefit are not apt to include obligations under a lease. Some rights under a lease, I suppose, might be counted as being benefits, but the obligation to make that property available to another party cannot be classified either as risk in the property, it just isn't, or benefit, it's neither. Now, if there was any doubt about that, we look down to clause 4.3 of this agreement, and that says, subject to the encumbrances set out at clause 4.6, the purchaser shall accept the transfer of title to the property, subject to the provisions contained in the constitutional documents, and such easements, restrictions and obligations benefiting or burdening the property in terms of this agreement, or any document referred to herein, or is imposed by any competent authority, but otherwise free from encumbrances. And 4.6 does not impose any encumbrances. There's no other provision in the lease that does so. It's not suggested that there is any other way in which the lease falls within 4.3. And the constitutional documents are things like the Master Community Declaration, which one gets in relation to all big off-plan developments in Dubai, but also the Strata Plan and the Strata Management Statement, which we're going to go to in a minute. And the Strata Management Statement, amongst other things, establishes the body corporate for a large multi-unit block like this. It sets out the boundaries of the individual units and it regulates their use. So not only do the terms of the sale say nothing about the lease, they expressly state that Emirates obtained possession. Possession is completely inconsistent with exclusive possession, which is what a lease amounts to. That's 4.1, and they expressly say that the transfer of title is not subject to any other interests. So just while we're here, if we go down to page 1241, if you see at paragraph 15, clause 15.4 on that page, you'll see there's also an entire agreement provision. Now, there was some suggestion below that this so-called assignment novation arose out of some other documents that preceded this sale and purchase agreement, but that is put to bed by this particular provision, 15.4, which makes clear that it supersedes any prior agreement. Now, the other thing that this document does is it expressly requires Emirates to comply with the terms of the strata management statement and ensure that everyone else does as well. So you see that's important, as I say, because the strata management statement prohibited the use as a bar and restaurant, and use as a bar and restaurant was required by the lease. So I'll take you through that briefly. We'll start with the sale and purchase agreement. If we go to page back up, please, to 1236, you'll see clauses 7.9, 7.10, and 7.11. If I just ask you to read those, please, briefly.
Well, what is the effect of that special permission that was given to the claimant to operate alcohol bar?
But by who?
Is it not exception? Yeah.
Well, I'll come on to the effect of that in a moment. What we're dealing with here is the lease. And what the lease is saying is you've got to comply with the terms of the strata management statement.
Okay.
So the permissions can't amend that document. They don't purport to amend that document. They might give rise to some sort of estoppel against the parties who gave. That's what's alleged. It can't give rise to an estoppel against somebody who didn't make those, grant those concessions. But they can't amend the strata management statement. So the point I'm making here is that the terms of the lease require I
know what you mean. One is
to comply with and
irrespective of what the law says, the two parties have agreed that there should not be any alcoholic bar there. So even if they got the permission from the authorities, that they're still bound by the terms of that strata agreement.
Yeah, but there's two parts of it. One is about the lawfulness of it, and if it's lawfulness, it's about the statutory obligations of the parties and the uses to which the units can be made. That comes later. I'm not addressing that quite at this point. This is simply a question. Could this sale and purchase agreement have been in any way construed as incorporating or transferring the lease with the units? And the answer is the opposite. What it does is it requires the purchaser, that's Emirates, to comply with the SMS, and the SMS is inconsistent with granting of the lease. So to say that somehow the lease, as I've shown you, was pleaded, the transfer was somehow subject to the lease, it just can't make sense, because the lease is inconsistent with the SPA, the sale and purchase agreement itself. So if we go down to clause 14.1, you see this. It says the purchaser will observe and perform, and will procure that the occupier will also observe and perform the purchaser's covenants at all times. And those covenants include, all the way down at 1257, covenant 7.1, that the purchaser will and will procure that the users and the occupier of the property will use the property strictly and exclusively in accordance with the constitutional documents at all times. And as I've said, the constitutional documents are defined to include the strata management statement. That definition. So that's at 1249. So the problem there, as we've seen, is that the lease was inconsistent with the strata management statement, because the lease requires and permits the use of the units as a bar and restaurant. That flows from clause 2.7, which actually positively requires the claimant to open up and carry on its business as set out in its license. That's at page K. We're back in, sorry, we've got to go to the lease for that. I apologise, we're not in the SPA. So if we pick up bundle K, which I'm afraid is where the lease is, and go to tab 1, go to page 2000, well, firstly, if we go to 2046, you see the definition of permitted use means the use of the premises as retail space for commercial activities in accordance with the tenant's trade license as Vegie LLC, or other commercial activities as approved by the landlord in accordance with the relevant trade license. And then you see it 2 points. If you go down to 2049, clause 2.7, tenant acknowledges there should be no delay in opening for business. So there's a positive obligation on the tenant, that's the claimant, to open for business and do all the fit out and all the rest of it. And then at 2051, the uses are set out at clause 3.4, 1 and 2. The tenant shall use the premises solely and exclusively for the permitted use and as authorised by its trade licence and for no other purpose whatsoever. So, and for good measure, we've now got in bundle E the trade licence itself, which shows you what those uses are. And that's at E11, page 1574. And the uses, the activities permitted are restaurant and lounge bar. So the position is that the lease purported to permit and require the use of these units as a restaurant and lounge bar. The strata management statement prohibited that, and the sale and purchase agreement contained a covenant requiring Emirates to ensure that users of the property complied with the strata management statement. So it would be totally bizarre if at one and the same time the contract assigned the lease which permitted and required those activities, but at the same time prohibited those very activities. Sorry, I thought there was a question. So it appears from the pleading, at least the draft pleading we saw, that those appear to be the sale and purchase agreements, which the claimant accepts were the sale and purchase agreements for the property. But we also know from the land registry entries that those are the correct documents, and they were, I think, provided also by the Registrar of Real Property. We've looked at those land registry entries. You don't need to go back to them. They're at D2, Bundle D, Tab 2, page 1218 and 1219. And as far as pleading is concerned, that is it. That is the whole case that was being asked and sought. It was said the 11th of January 2012 sale and purchase agreement was expressly subject to the lease. It wasn't. To the contrary, it contained specific agreements that it was not subject to encumbrances and specific promises to abide by the SMS, which would have been inconsistent. So then there's this assertion that's made now about the existence of a master sales agreement covering the retail units. That, it's said, is the novation. And so there must be some other agreement novating this lease. That is pure assertion. Now, as His Honour Roger Giles has pointed out, that would have to amount to a novation. That is nowhere alleged in the pleadings. It's said that the sale was made subject to the lease. There's nothing about a further agreement in the pleadings whatsoever. Certainly, the claimant never says all three parties got together and agreed to a novation. There was at one stage a proposal that there would be a master sale agreement in relation to the retail of Limestone House. That was a proposal as between Emirates and Union Properties, nothing to do with the claimant. We see that proposal in Bundle D, Tab 2. And if we go to page 804, so what you see here is an email from Union Properties to Emirates, and it says, "Dear Melanie, kindly note we've sent the master sale and purchase agreements for EMBD for perusal last Thursday. Attached is a copy from the email sent. Therefore, we highly receiving your comments," and so forth. And then there was a draft master sale and purchase agreement for Limestone House units, and then it says residential/retail. Do you see that on page 806? So the suggestion is, well, this then became a master sale agreement for retail. Now, there was one for residential, but my case is that there's just no evidence and no real prospect of establishing, even if you can go beyond the pleadings, there's no real prospect of establishing that there was one covering the retail. And amongst other things, even if this became an agreement, a contract between the parties, it actually says, again, quite the opposite to the case that's being put. Because if you go forward to page 808, firstly you see 3.1a, what's provided is possession and occupation of the units shall be given to the purchaser, and all risk in and benefit in respect of the units shall pass to the purchaser upon the purchaser signing the seller's standard SPA for the units. So again, possession and occupation is wholly inconsistent with there being a lease in place. But then over the page at 809, you see clause 3.6. It says it's further agreed between the parties that in the event of any contradiction between the terms and conditions stated herein and in the individual SPAs to be signed by the purchaser acknowledges and agrees that the terms and conditions of the individual SPAs will override the terms and conditions stated therein. So this document, even if it had led to an agreement, couldn't even begin to superimpose some sort of transfer of the lease on top of the SPA when the SPA says that didn't happen. And anyway, it was never in fact agreed. There never was a master sale agreement for the retail. We know that for a number of reasons. First of all, there have been repeated searches for this particular document and they have not been found. And secondly, the former Chief Financial Officer of Emirates has said there wasn't one. You see that in two places. Firstly, from the witness statement of Mr. Hadi Brocklehurst, we go back to it. It's bundle E, tab 5, page 1453. And it's the second half of that paragraph there. Nonetheless, further searches in the raw data harvested for the document production served in February, and inquiries by my team members into former staff member Rajef Mistry have failed to produce such a document. Indeed, Rajef Mistry recalled that while a master sales agreement was signed between Union Properties and the first defendant in connection with certain residential properties, the sale and purchase of the retail units, including the disputed Vegie bar units, were documented by signing individual sale and purchase agreements only. And then he says, for completeness, a copy of the master sales agreement for Limestone House relating to the residential units is enclosed. Now, there was that harvesting error at the time that Mr. Hadi Brocklehurst gave that statement, so the process was repeated again, and you see again in Mr. Barrack's evidence, which you'll find at tab 7 of the same bundle, E tab 7, and he deals with it at paragraph 13 on page E71475. He says again, further searches for the document were done in relation to the wider sample of documentation. Nothing was found, and indeed Mr. Rajef Mistry confirmed that there wasn't one. So now, if the claimant had actually sought to amend to allege an agreement of this sort, and it doesn't actually, never did actually do that. Even now, even the proposed pleading that's put forward now, with even further amendments, doesn't say anything of the kind. It would be for the claimant to make out that it has real prospects of establishing that this alleged agreement exists. The absence of evidence can't obviously establish the evidence. And the point is this, that if there is to be a novation, this is an agreement to which the claimant would have to be a party. So the claimant would be able to produce it. The claimant has never said, well, we sat down and we all agreed together that this happened. Now, there was a creative argument below that the defendant was ordered to produce it, but in fact it wasn't. It was just ordered to make standard disclosure. But in any event, even if you take my friend's case at its highest and you accept Emirates just can't be trusted These aren't mistakes. This is a grand conspiracy. As I say, what the claimant is alleging is an agreement between Union Properties, Emirates, and the claimant, which provides for the novation of the lease. So that agreement would be in the hands of all three of those parties. The claimant hasn't produced it, doesn't have it. The defendant has looked for it and hasn't found it. The registrar of real properties has been ordered to produce it if it exists. It doesn't exist. But also, the other potential culprit for all of this, Union Properties, has also specifically been ordered to produce this document. And you see that in Bundle K at tab 7. So this is an order of the Court of Appeal that was made, I think, in March 2017. And if you look at paragraph 1b, the application for disclosure was granted in respect of the following documents. And then the master sales agreement for the sale of the units in Limestone House and Index Tower from Union Properties, PJSC, to the respondent. And when it came to it, Union Properties, I think they attended court, in fact, and produced the, quotes, master sales agreement. But it was the master sales agreement for the residential properties. The evidence for that is, I think it's in Mr. Hadi Brocklehurst's statement. It's E tab 5, page 1453, paragraph 6. But effectively what's happened then is that Union Properties has been ordered to produce the, quotes, master sales agreement, and it said this is what we have, and it's produced an agreement that doesn't cover the units. Now, Union Properties would have the strongest interest in showing that there had been a transfer of this lease to Emirates, because that would get it off the hook for selling the units without the lease. Because if it didn't transfer the lease and the lease wasn't registered, then there's a potential claim by the claimant against Union Properties. So it's got to be in Union Properties' interest to produce this document if it exists. But Union Properties has no trace of that document either. And it's never said that such a document exists. It has never alleged that there was an agreement to assign, an agreement to novate. All it has said is that Emirates knew about the lease and is now the owner of the property. I'll show you that when it was first alleged against it. The claim was first brought against it by the claimant, I think. I don't think a claim was actually brought, but it was intimated. If we go to Bundle K and tab 3, you see a response that comes in from Union Properties. This is in June 2015. Reference to your letter dated 15th June 2015 with the aforementioned subject. When UP was the owner of two mentioned units, UP have rented the shops to the tenant. The tenant was recognised and we've entered in a 10-year lease agreement on the 1st of June. However, within the lease period, Limestone House Retail was sold to Emirates MBD. During the transition, all documents and related documents were provided to EMBD related to the existing lease agreement and any other issues, which includes your lease units LP5 and LP6. Therefore, all the preceding transaction and communication should be addressed to EMBD, which is the new owner of Limestone House Retail. Go and ask them about it effectively. So that's all it says. So what we can take from that is A, Union Properties is never said that there's some additional agreement in relation to this lease, or even some supervening overarching agreement in relation to all leases which caught this lease. Union Properties just simply clearly thought that, given it thought that Emirates knew about the lease, and given Emirates had now taken ownership of those units, that was enough to transfer the lease. But we know, as a matter of law, that it isn't. And that is the same assumption as apparent in all these other documents on which the claimant puts such heavy reliance. So we've got this document that's been referred to as a notice of atonement. That comes in Bundle D, tab 6, and we'll just go back to it very briefly. And if you go to page 1288, we see it again. It doesn't say anything about atonement in that. That's a label that's been attached to it by Mr. Bowden. But that simply says, this letter is to inform the lessee of the transfer of ownership of the above unit to Emirates Properties. Union Properties will no longer be managing the unit, And then it says your contractual interest has now passed from Union Properties to the above named company. So it's completely consistent with this assumption that the transfer of the ownership carries with it the lease. But it doesn't. It doesn't say, and it never has said, that there's some other agreement. And as I say, that agreement would be inconsistent with the terms of the sale and purchase agreements for these units. And it would be improbable. Why is it that the parties would agree that Emirates was getting these units free from all encumbrances and then suddenly change its mind very shortly afterwards, after signing the SPA? And that's certainly not the way the case is put. It's not put like that at all. It's just put as that it went with. So that the pleaded case is consistent with this, but it doesn't make out a case that there is some other novation or agreement. And then the claimant then makes all these other points, again, which don't feature in the pleadings. So the claimant points to payments made by the claimant to Union Properties before it was sold before it sold the units to Emirates. So Mr. Bowden clarified that it's not being alleged that any payments were made directly by the claimant to the defendant. So, but nevertheless, the claimant characterises what happened as the defendant, as Emirates, receiving or collecting rent. But that, I suggest, is a misleading characterisation of what happened. There was no payment from the claimant. The claimant had already paid. And the schedules that are referred to are simply reconciliations as to what was owed between Emirates and Union Properties. It is an accounting between Emirates and Union Properties of what was due between them as a result of the transfer of these properties, to calculate the final amount due to Union Properties in respect of the units. And again, you'll see that when you look at the particular pages that I've picked out, are pages D2932 and D2940. But as I said in my skeleton, at best one can say that those calculations were prepared on an assumption that the lease went with the transfer of the property, and so they're wholly consistent with the letters from Union Properties that because the ownership had been transferred, therefore the lease was transferred. But that doesn't solve the problem. Where is this agreement? There isn't an agreement for transfer of this lease. When you look at the actual sale documents, when you see that no one who would have to be party to this agreement, who would have an interest in producing this agreement if it existed, including the claimant, including Union Properties, has been able to produce a document which matches that description. And when the CFO of Emirates said, well, actually, we decided not to do it that way, there just isn't one. And also when you actually look at the agreement that was being considered, the master sale and purchase agreement, then you see that that in itself didn't purport to override the terms of the sale and purchase agreements. Now, at least in its skeleton argument for today, the claimant, Mr. Bowden, accepted that this reconciliation, what he calls collection of rent, but I call a reconciliation between these two parties, did not give rise to an agreement to assign the lease. He says that in terms in his skeleton argument. You find that in his submissions. Bundle B, tab 15, page 251 is the submission itself. If we go into paragraph 32, when he discusses my characterization of what happened, this is on page 261, he says there's never a mistake. And then he says the collection of rent does not create an assignment, it is proof of it. So again, you heard today that he wants to shift again to make the case that actually there was payment of rent, rent was received, and somehow a lease arose as a result of that. That would be an entirely new claim, one that's certainly not pleaded, one which would be statute barred at this point. It's said that this occurred in September 2012, and the limitation period for claims is 6 years. That would take you to the latest, to September 2014. And anyway, it wouldn't get you to a 10-year lease. Can I ask that whoever's doing it, please just stop manipulating? I think are we all following still the presentation? Perhaps we should all just stop following the presentation. Maybe it's my fault in any event. You also heard some towards the end at least, an argument that the so-called letter of atonement might somehow create a lease. But actually earlier in his submissions, Mr. Bowden had accepted that couldn't create a contract, create a lease either. And then you also had this idea that somehow the signature of the registration document for the registration of the lease in May 2012, somehow that might have amounted to an agreement or amounted to a novation. Again, there's absolutely nothing in the pleadings that would bring that out. And actually, let's go to that document briefly, if we may. I think it's in Bundle E, page 1572.
I'm not too sure whether we have lost Judge Ali.
Ah.
Judge Ali, are you there?
Yes, I'm around.
Okay, good.
I'm still awake. Yep.
Where was it again? The
It's Bundle E.
Montague?
Bundle E, page 1572.
Bundle E, 1572. 1572. Okay. 1572. Okay. Okay. 72.
So this is the document which was signed by Ms. Fernandez, and it was for the submission and registration of the lease back in May 2012. But the question is, what's the legal effect of this document? And there was some vestiges of an argument being raised for the first time by Mr. Bowden that somehow this might create an novation, or this might create something else. It clearly can't create a novation when Union Properties is not party to that document. But B, more generally, this is a real property registration form. This isn't a contractual document. It's not the sort of document which shows the intention to enter into a contract. But in any event, this is all by the by.
What's the purpose of signing those documents?
Well, clearly, Mr. Fernandez believed that the lease needed to be signed. But the question is, that can clearly be right or that can be wrong. But the question is, what's the legal effect of that? So there's two potential arguments relating to this. One is it creates some sort of contract, and the other is it evidences that there has been a transfer of this lease. But as to the creation of the contract, I don't even know whether that's alleged. But if it is, it can't work, just because Union Properties isn't party to this, and also it's not a contractual document. Does it evidence the existence of some other document? It's consistent with that. It's also consistent with what I've been saying, which is that there was this assumption that just when you transfer the property, the lease goes with it. What it can't do is magic up a novation which doesn't exist. And if that novation existed, the claimant would have it. Union Properties would have it.
But the purpose of you signed there, I expressed there just now, the name from Union Properties has been changed to Emirates, isn't it?
Well, the name is simply.
So the idea is to recognize, although it was not properly presented for registration, but the purpose is. That's why he alleged you defrauded him, because after signing that, you don't want to honor your contract.
But it's not. The question is, by signing that, does that somehow create a contract? Does that somehow bind the lease to Emirates? And the various ways in which that's alleged, I'm exploring now. My starting point, though, is really got to look at the pleadings that were being sought, and they don't work. They just don't work. And this document can't override that. Clearly, it is consistent, and I accept, with the position that Ms. Fernandez at that stage thought there was a lease and thought that Emirates had to register it. But the question is then, well, where does that get you? And in circumstances where you would need a novation to which the claimant was a party, which it doesn't even allege, there isn't a claim here. There just isn't a real prospect of success on this. And in my, again, we won't go to it, but in my skeleton argument, I refer to a relatively recent case from the English High Court called Kwa Su Ling, and we don't need to go to it, but it illustrates the position where a party shows up to court and says, well, I have real prospects of success because there just must be some further documents out there. And the court in that case noted that the defendant had filed a disclosure statement saying that the documents didn't exist, accepted that, and determined that in the light of that, the case was speculative and the amendment was refused. So this is partly why I drew to your attention where we are in this case, 4.5 years down the line, what the likely value of this case is going to be. And it's in that context that you have to think, look, realistically, is there any real prospect that the claim is going to establish a novation of this? And I'll come on to registration in a minute, but just dealing with novation.
Can I pause you for a moment?
Yeah.
There was he didn't file his claim until 3 years past the date that he was supposed to get possession. What was the justification given by him? Why he delayed his filing his claim?
The claimant?
Yeah, the claimant.
I don't know. I think that's a question for Mr. Bowden.
Okay, thank you.
I don't know, I'm afraid.
I thought he's...
So no, yeah. I don't know, I'm afraid. But
did he mention somewhere? I can't remember. Too many things. Yeah. Okay. Never mind. It's okay.
I'm sorry. I don't have it.
Sorry. It's okay. It's okay. I should have asked him.
No.
Go on.
I don't know the answer to that question. I can look it up for you subsequently if you.
No, there was a mention something like there was no real good reason was given or somewhere mentioned.
Oh,
okay,
I see.
Never mind.
That was more about this. That's more about the progress of the proceedings, because as I said, in January 2018, there was the order for disclosure in February, and then it's not until November that you get the application for further disclosure, amend the case, and so on. There's a gap of almost a year, as the judge puts it. It's not quite a year. It's a long gap. And there's no justification for that. Okay. What I was just saying that the court and what the judge grappled with below was, look, in this context, is the claimant really in a position to establish that there was a novation of this lease? As I say, I'll come on to equity, I'll come on to registration in a minute. But the answer is going to be the same as today. The claimant's going to have no evidence whatsoever of an agreement which it would have to be party to. And instead, the court's going to be faced with the contract by which the units were sold. And those contracts make clear it's not subject to any encumbrances, including the lease. And so, as I say, my position is you've got to keep Mr. Bowden to his pleadings, otherwise this all goes completely off the rails.
So basically, your defense is that the claimant has not pleaded properly, and his allegations, his facts, the evidence adduced do not relate to his pleadings. That's your general...
That's my first point.
Yeah.
But my second point is, even if you allow him to run this other claim,
yes,
what is alleged, he sort of falls back into, oh yeah, well, all right, I'll allege a novation if I have to. But that's a factual allegation. That's an allegation of a factual agreement entered into between three parties. He doesn't have any evidence to support that. He doesn't have any pleading to support that.
He's saying there was an implication of novation because of all the documents you signed.
An implication. Well, he put it in a number of different ways. So he said, well, this is evidence that there was a novation.
Evidence, there was novation.
But that doesn't solve the problem. That he doesn't actually allege the novation anywhere, and has and doesn't support it with the document that he has said his client was party to, or has to say that his client was party to. How did this agreement actually come about? The next question is, well, all of that evidence about payments, about documents being signed, there was, I agree, some suggestion at various times that he was saying, well, that actually brought about a novation. That is a long way from what is pleaded. It's not what is pleaded. But also, he disavowed that expressly at various stages. So, and again, as I say, my fallback on that as well is, well, it just can't get around the express terms of the SPA, the sale and purchase agreements, and the fact that he would need to produce this document. And everybody who's been asked, the registrar, Union Properties, the defendant, and obviously the claimant hasn't been asked, but would produce it if it had it, none of them have a trace of that document. So that's the first argument that's put forward, and I was going to leave it there on a novation assignment unless you have any further questions on that, and move on to deal with this issue of registration. Now, what you really weren't told by my friend when he was explaining his case on registration was what the registrar of real property says happened, and I'm going to show you that if I may. His case is that the lease was registered, and somehow that means that there is a case, and I say that's wrong at both parts. Both parts of that argument are wrong. The first part, that it was registered, is a very difficult argument for the claimant, because the registrar of real property has said in terms the lease was not registered. It was never registered.
Yes.
And in that case, it is frankly highly surprising that the claimant seeks to persist with this part of its case. So the registration form that we've seen was submitted, but what the registrar says about it is that it was not registered and could not be registered until the strata title plan was registered, and that didn't come until 2014. And by then, Emirates had withdrawn the attempted registration, and therefore it was never registered. So what happened by agreement was that the court asked the registrar of real property to explain what had happened and ask specific questions. And I'll show you that. It's a tab, it's bundle F, tab 7, 16, and if we start at, it starts at 1618, but if we start at 1620, please, just at the top of the page, and just go through what is actually said here. Question, paragraph 8.1. Whether the lease was ever registered under both units in question within the meaning of DIFC law prior to the sale of the units to Emirates MBD Properties on January the 11th, 2012, during the period of possession by Union Properties. So that's the position before Emirates becomes the owner. Answer, no lease was registered. Then they ask the question, what about afterwards? Paragraph 8.2. Whether the lease was ever registered under both units within the meaning of DIFC law on or around 28th of May 2012 during the period of possession by Emirates MBD. Answer, no lease was registered. And I'll come on to show you the explanation for this. Details of any removal of the lease, including any record required to be kept. Answer, no contract of lease between the claimant and Union Properties or Emirates MBD Properties was removed from the register required to be kept by the RORP under Article 16. And then, for good measure, details of any master service agreement pertaining to the units, and then it says no details to be found. And now, what the registrar has given, A, the reason why there was no registration, and B, an explanation of what in fact happened. And you have to bear in mind, Mr. Bowden conceded during his submissions that the form of registration is a matter for the registrar. So the registrar is the sole determinant of what counts as registration. He said that in terms. And so it must therefore be right that if the registrar said that was not registration, then that by definition is correct. It can't be challenged. So let me show you, take you briefly through the reason why the registrar said that it wasn't and indeed couldn't be registered in May 2012. So if we start at F, bundle F, just over the page, 1621, down at little f, it says, where it involves the creation of a folio in the DIFC register, where strata title rights are involved, such as is the case with Limestone House, where the relevant units are situated, Article 39.1 of the law stipulates that certain requirements first need to be satisfied, including under Article 39.1e, approved building plans that need to do certain things, and they need to bear the certificate of the registrar that the boundaries and so forth are properly delineated. And then there's all other certification information required by the registrar. We can skip down a bit to H on the next page. To meet the requirements of Article 39 of the law, the registrar requires on developers to adhere to the obligations of Article 9 and 10 of the Strata Title Law, which requires a developer to register a strata title plan with the details set out in Article 10 of the Strata Title Law, and to file a strata management statement providing the details as to how the development's management, maintenance, shared expenses and shared services will be dealt with. In the case of Limestone House Development, strata management statement was registered with the RORP on 2nd of July 2012, and the strata title plan was submitted on the 14th of January 2014, which was accepted for registration by the RORP on the 16th of January 2014, and then explains why there was a delay. It's not really relevant. There was a dispute as to certain penalties. And then K, accordingly, the strata title plan could not be filed prior to the finalisation of the formal survey of the property that formed part of the above proceedings and the final GFA in relation to plot GB01. And then L, given the requirements of the law, the principles underlying the torrent system and the duties of the RORP pursuant thereto, the RORP was legally not in a position to create folios of units in a development without the strata title plan and strata management statement having been filed and registered by the RORP. And as a consequence, the folios in respect to the relevant units were only formally created in the register on 16 January 2014, after which the units in the development were transferred to Emirates MBD.
In this context, what does folio mean?
Folio is the file which is created in the register for receipt of the documents in relation to that particular parcel of land.
Unit or parcel of land.
Yeah, that's probably a poor summary of my understanding of it, but there we are.
Okay.
Now,
Mr. Smith,
yes.
Can I ask a question at this point? This is what piqued my interest in the question I asked of Mr. Bowden. That last sentence, after which the units in the development were transferred to Emirates, indicates transfer of something in 2014, whereas it seems to be accepted that there was a transfer of the freehold to Emirates in 2012, end of March 2012. Now, what's the reconciliation of that?
I don't know what the answer to that question is, but what it looks like is that the dates of registration recorded in the title documents have been related back to an earlier date. I don't know, and nobody's ever asked that question. But it doesn't matter for these purposes because... Sorry, you can ask another question.
I was going to say another explanation might be that you can have a transfer of the undivided freehold in March 2012, and then upon the strata plan being registered, there are separate folios created, and each one of those is registered as a transfer. But that doesn't make entire sense when the SPAs were for the individual units.
And the registration on the title document appears to be for the individual units. So, I mean, I agree that there's a tension there. And I can think of ways to explain it, but it's right that the RORP has not been asked specifically about that. But it doesn't matter. It doesn't matter because the question that we're looking at for these purposes is, was there registration? And whether or not the registrar was right or wrong that there could or couldn't have been registration, all that goes to show is that the registrar did not register the properties because it thought.
What it does is transfer is change the date at which we are asking the question, but you say the answer is the same.
Well, it doesn't though, does it? Because the question is, was it ever registered? And we'll go on to see what actually happened to it. But the registrar is saying, this is my reason why it was never registered. And now, if that's right, then it's not possible to register, and this part of the case must fail. But even if he's wrong, the question, as a matter of fact, is: did he register? Was that lease registered, put onto the publicly available register? If it could have been, it wasn't.
That's why, and just to make sure that my thinking doesn't need correction, I said that your answer is that the answer remains the same. It doesn't matter whether the lease was registered prior to the 29th of March 2012 or prior to some date in 2014, because the answer is the same. No.
Yes.
Have I got? Do I understand you correctly?
Yes, that's correct. That's correct. It doesn't matter. But it is worth looking at what the registrar said did in fact happen to this lease. And what happened was that the details of the lease were, as Mr. Bowden has said, entered into a spreadsheet in May 2012. Now, the purpose of that spreadsheet is explained in terms by the registrar, little letter Q, on page 1623. And it's worth reading that in full. And I won't read it out for time, if I might just give you the chance to read that.
Yes.
So this was according to the registrar of property, who has no skin in the game, no reason to take a view or take sides on this, just telling us what happened. This was a practical means of keeping a record of a lease having been entered into in the jurisdiction to satisfy the registrar of companies that there was a lease, and it was required. That was required for issuing a trade license to a company. It was not registration. It was not a system of registration that had been established within the meaning of the real property law. And as Mr. Bowden said, and as is right, it is up to the registrar how to establish that register. And so if the registrar says this wasn't the register, then it's at trial. How is a different conclusion going to be reached? It just isn't. There had been a suggestion previously that there had been provisional registration. That wasn't my suggestion. That's just a shorthand that was given by the registrar for what had happened. And it's right, there is no concept of provisional registration under the real property law. And yet, so what my learned friends previously tried to do is he said, well, if there's provisional registration doesn't exist, therefore provisional registration must just mean registration. But that's a non sequitur, and also it just doesn't examine what the registrar actually says happened with the details of this lease. What there is in relation to, particularly in relation to the protection of leases, is a system of caveats, and that arises under the real property law, and that's the ordinary way in which you would protect your unregistered rights in relation to property. The effect of a caveat, if you've got a lease, you might be able to register a caveat with the real property registry, and then that would prevent a sale of the property unless the caveat was released. And so you have control over the circumstances, and you might require, for example, that there be a novation of your lease as a condition of the sale. But it doesn't create, the caveat doesn't create an interest in land either, and no caveat was ever entered. So it seems to me that at best, really the claimant's case in relation to this is that once that plan arose, or once that plan came in and the registrar felt able then to start registering instruments, then the registrar should have registered the lease in the registry. And that happens in early 2014. But that takes the claimant no further than its argument that there was an assignment. Because what is being said is then, well, there's an obligation to register this lease. Not that it has been registered, but that it should have been registered. That depends on whether or not there's a lease which has been novated or assigned or whatever to my client, and therefore a lease to which my client is bound. And also, the other point about that is it's fundamentally wrong to advance that against my client, because it's the complaint, if there is one, should be directed at the registry. So that's the first point, is that simply put, there's just no...
Mr. Mutek-Smith, if I may ask,
Yes.
Is it in your argument that mere filing the registration form does not amount to a registration?
Yes.
Because this is just mere an application. So the authentication or the record of the lease is something for the registrar. If we found all requirements are adhered to. And that a record, only the registrar of real property can answer, not the registration form itself.
Yes, there's no, just filing registration is not sufficient. There's a process of registration. So the register itself can be searched. And so the details need to be entered onto the register in a format that can be searched by the world. That's the whole purpose of the registry, is to make these property rights available to the world and therefore binding on the world. And so it's not just a question of when you file the document. It's a question of whether it's in fact, whether it is and when it is in fact registered.
I see, thank you. You may continue.
So that's the first part, was there registration? But the second part is, well, what is the effect if there was registration? And this is where I say the argument is completely misconceived, because the point about registration, the point about entry on the register, is that it tells you what rights exist in relation, what in rem rights exist in relation to that land as at the date that the register is interrogated. That's the whole point. So when you go to buy a property, you look at the register and you can see what are the rights that affect the property. And so when Emirates bought the property and when it sold it, the lease was not registered. There's no dispute about that. So there was no in rem right affecting the purchaser, affecting the land at that time. So the mere process of registration does not create a contract. It doesn't create a binding lease any more than a contract creates registration. So the entire argument based on registration just as registration is misconceived. It's not alleged that it was registered before my client bought the property, and unless the claimant can show that there was a novation or some other agreement, some other way in which my client became bound by the lease, then registration has no effect because there's no registration now. So say, for example, that there was an error and a lease, so there's no contractual assignment or novation, but a lease is nevertheless registered and entered into the registry, and that is then subsequently corrected. According to the law, the effect of that is as if the registration had never happened. That's Article 1492 of the Real Property Law. So I'm not saying that that's what happened in this case, but it shows you that the point is that the whole idea is that the register is conclusive, and it's conclusive as at the date that it's interrogated. And so it doesn't matter if there was an interim period. I don't say there is and there's no evidence that there is, and indeed the registrar says there wasn't. But if there was an interim period of registration, that would not somehow cause the lease to become binding on my client. So the point there is that really this argument about registration just takes the claimant's case no further than its argument about novation. If there was no novation, there was no right to registration. And so in relation to that as well, I say the Deputy Chief Justice was plainly right to say that there was no real prospect of establishing a claim based on that. That's all I was going to say about registration, unless anyone has any questions about it. I was then going to go on and deal with this question about equity. Now, so the equitable lease argument, this idea that there's some sort of equitable way in which the lease binds the defendants, has to start from the position that there was no novation, because if there was no novation, you don't need it. So if there's no novation, there's no contract between Emirates on the one hand and the claimant on the other. Nevertheless, the claimant says, well, in those circumstances, Emirates could still be bound to the lease. And this is argued under Article 31H of the Real Property Law. And we should just have a quick look at that, I think. It's in Bundle I. There's only one tab in there, and it's page 1695. And if you look at, so you recall, if we go down to Article 30, we see on page 1695, Article 31, subject to this law, a registered owner holds the registered interest subject to all prior interest is registered or recorded in the folio of the register for the relevant lot, but free from all other interests. So it's only registered interests that affect subject to the law. And then 32A, in particular, the registered owner is not affected by actual or constructive notice of any trust or unregistered interest affecting the lots. So that's the starting point. And then the exceptions we see at Article 31 over the page, on page 1696. A registered owner does not obtain the benefit of Article 30 in relation to the following interests or rights affecting the lot. And then it's H, an equitable obligation binding the registered owner as a result of the registered owner's conduct. So the first point that you see here is this is all about what interests an incoming owner is bound by when they take the registration. So, and it's right. It's been pointed out that this particular exception does not survive the amendment to the law, and I don't think there's an awful lot of authority in relation to what it means. But it talks about an equitable obligation binding the registered owner. So, what is pleaded in relation to this? We go back to the pleadings. We have to recall that this is now 4.5 years into the case. What is the conduct? What is the equitable conduct relied on? So bundle B again, tab 16 again. And if we go to page 286, please. And paragraph 62. So this is under the heading second and alternative cause of action against first defendant, equitable claim. So this is the amendment that's being sought to be introduced. Paragraph 62. The sale of the freehold interest in Limestone House by Union Properties to the first defendant was expressly subject to and made with notice of the leasehold interest of the claimant who held the further lease in the same terms as if it had been registered under the DIFC law of property. 63. The equitable obligation arises by operation of equitable estoppel, the doctrine of anticipation, and the rule in Walsh and Lonsdale, which apply irrespective of any registration. And then it's just 64, tried to gain access. So we have the repeat of this allegation that the sale was expressly subject to the lease. Well, we've seen that it wasn't. And then it said, and made with notice of the lease, and then leads into the equitable estoppel assertion. So no other particulars of the alleged estoppel are set out at all. What's being said here in the pleading appears to be that it's the notice of the lease which creates this equitable interest. But as we've seen from the law, notice of a prior unregistered interest doesn't cause the owner to be bound. And that's the fundamental tenet of the whole system, and something the claimant now accepts. There's something more than mere knowledge is required. You need something else. And again, there's just nothing, there's no pleading, there's no case, none. Now, at some points it said, and below it was said in argument, orally, well, there's an estoppel. And there were shades of an estoppel argument being run by my friend again today. So what do you need for an estoppel? Well, I've provided a summary in Chitty, and I won't go to that, but if you need it for later for reference, it's L, tab 15, page 2553, in paragraph 4146. But to get to a proprietary estoppel, so an interest in a land arising from an estoppel, you need a representation or assurance which amounts to a promise of an interest in land. You need detrimental reliance such that it becomes unconscionable to deny the interest. And detriment is a real obligation, it's a real part of this. And usually what you end up with is where this arises is where somebody has relied on a promise that they're going to get the land, and they then improve the land. So somebody says, I'm going to give you that piece of land, so they go ahead and they build a factory on it or whatever, and then the other person comes back and says, oh, well, actually, I'm not going to give you that land after all. They can be stopped from saying that, and you can get an interest in the land as a result. Now, none of those parts, none of those elements of estoppel are even pleaded. I'll show you how it was argued orally below. If you go to the transcript, bundle C, page 431. And it's here, top of the page, it said, an estoppel, sir, is created when we have acted to our detriment in reliance upon what the landlord has done. Here we paid the money when intending to enter into the lease. So we've placed reliance upon them. That is indeed the next point, feeding the estoppel. We fed the estoppel by the payment, and they've fed the estoppel by signing the lease registration form, whether it was registered or not. So there's an allegation, therefore, that the lease registration form, the signing of that, was the representation or the promise. It's not a promise, though. It's not a promise that could give rise to an equitable estoppel. But in any event, what is said is that the payment is the reliance, but that comes before the alleged representation. So the estoppel case just doesn't work. There is no possible reliance on any representation. No estoppel could emerge from that. And it's worth noting in this, and we'll come on to this, but the lease has been on hold since March 2012. And what was said in submissions by Mr. Bowden was that by the time the claimant decided it wanted to get into the property, I suppose that's in November 2012, Emirates had told him to go away. That's what Mr. Bowden said. So by the time the claimant started taking any possible steps at all to try to get into the property, this alleged promise or alleged representation had already been withdrawn. So there's just no building blocks for an estoppel here whatsoever. And this ground's barely argued in the supplementary skeleton argument. You can see it. It's at B tab 15, page 275, paragraph 76 to 77. There's really nothing there. 275. This is the equitable case as it's put, and the only allegation is 76 and 77. If there was an assumption that the lease was transferred and EMBD has accepted rent on that assumption, Walsh and Lonsdale will cure any inequity created by that assumption, providing that was what was agreed to be done. So there's a kind of blurring of the Walsh and Lonsdale provision, which is to say you can have an interest in land in equity under English law where you have an enforceable contract, and on the other hand saying, well, you can actually create a contractual obligations or other rights by estoppel, but there's still no explanation of what was done in reliance, in detrimental reliance on any kind of representation which would even begin to make it unconscionable to go back on that. And so this comes close to sort of arguing in effect an estoppel by convention, but again, you still need reliance, you still need detrimental reliance to establish that. And if you need authority for that, you can find it in my friend's own authorities. In the Lancaster case, I'll give you the references now. J tab 4, page 1827 at paragraphs 32 to 33, and also in Brown and Root, J tab 8, page 1848. And this reliance on Walsh and Lonsdale, again, is also just completely misconceived, because that's an authority, as I say, which establishes that an agreement for a lease which is capable of specific performance can be treated as in equity as having the same effect as a legal lease. But you still need a contract, you still need a binding agreement that's specifically enforceable. So equity doesn't intervene to create contracts, they're two distinct branches of the law. So the equity argument just doesn't even get off the ground, even now, even if it's taken beyond what's pleaded, and nothing really is pleaded. So my friend has to succeed on one of those three grounds to show that he has any real prospect of success. But I say also there are two potential defences, two defences which can be made out in law, and which show that the claim can't succeed anyway, even if there was some sort of transfer. So I'll deal with those now quickly, unless there are any questions on that first part. Thank you. All right. So we've got to assume somehow that the defendant would otherwise have been bound by the lease. And so I say that if that was the case, then the contract would be void or unenforceable in any event. And that's as a result of two things. And the first of those is an amendment which occurred in March 2012. And now that obviously came after the sale of the property. So this is on the assumption of my friend's case that somehow Union Properties was acting as the agent of the claimant when it agreed, sorry, the defendant when it agreed this amendment. But in any event, operating on the hypothesis that there was this transfer, the case that's put is that there was this amendment. The amendment itself you will find recorded in Bundle D, tab 2, page 857.
Mind repeating that, please?
Sorry, 857.
D857.
Correct, yes.
Thank you.
Thank you. So you'll see it's dated, it's the letter dated 15th of March 2012, and it's a letter issued by Union Properties, and it's issued to the claimant. So it's a variation of the lease, and what it says is, it talks about a meeting, and they say both parties agreed for the following. One, the terms of this are quite important. Since Vegie Bar was the first retail operator to approach and sign a lease agreement to lease retail spaces in Limestone House from almost 3 years back, Vegie Bar interior fit out to be postponed again until progress and development is achieved with the commercial spaces available in Limestone building, since Union Properties did not fully lease and develop the retail area in this building. 2, all checks issued by Vegie Bar in favour of Union Properties are to be put on hold and replaced when the progress of leasing the rest of the commercial units is achieved. And then 3, lease commencement date and rent commencement date to be adjusted and revised towards a new date once the progress of the occupancy is achieved. However, all other terms and conditions of the agreement remain the same. Now, this is pleaded out in terms in the pleading, even as proposed to be amended now. You see that at B, tab 16, page 281. Paragraph 28. And in particular C, the further lease commencement date and rent commencement date was to be adjusted and revised towards a new date once progress of occupancy of the commercial units was achieved. So the case is that the lease was amended in the terms of the letter, and as we've seen, commencement date goes back in those terms. Now, in the pleading below, the claimant tried to give some content to this question of what counted as progress. And so you see it at paragraph 31 in the text that's been struck out. This is the case that was being advanced below. The first defendant, you see that 31, on 23rd of April 2013, confirmed that the commencement date of the further lease could be extended until Limestone House retail was 60% leased. So you see that in the struck out words in paragraph 31, and then in 32A as well, in the struck out words there, you see it, the extension of time for the commencement of the further lease bound the letter to make the premises available to the claimant, either A, I'll come on to B, but A, when the surrounding shops are 60% leased. So the case below was that was what progress meant, but that now appears to be abandoned, and rather strangely, the claimant said, well, that was the defendant's case. You see that at the new paragraph 31. But in any event, it was clear that it was the claimant's case, that the agreement to defer, you can see 32B, was a condition which the claimant could waive. And I'll come on to that. It's not a condition, it can't be waived, but in any event, there we are. But we see now that the original pleadings that were being advanced below are not, as to when the lease would commence, what this actually means, are not now pursued. 31 is completely replaced, 32A is completely changed. So why is the claimant trying to sort of wriggle out of its own case in this? And the reason is because the effect of the agreement, we say, was to put the lease on hold indefinitely. And the reason why that is the case is because it is not possible to determine from what was agreed, looking at paragraph 28C, looking at the letter that we've just looked at, it is not possible to determine from that agreement when the lease will start. And as a result, it's not enforceable. And my friend says, well, you know, he takes quite a crack at what I say about this, and he says it's all a bit of a joke, and he refers to Blue and Ashley as a humorous case. But it is worth just looking very briefly at what Chitty says on this, if we may. I'm making decent time, so hopefully we can just look at that without testing anyone's patience too much. It's tab L, sorry, bundle L, tab 15. Page 2550, and it's paragraph 2-148, where it says an agreement may lack contractual force. Have I lost anyone?
No, I don't know. Roger, are you there?
Yes, I'm here.
I'm here
Okay,
too.
good.
It may be me, so I'll carry on. An agreement may lack contractual force because it's so vague or uncertain that no definite meaning can be given to it without adding further terms. Gives some examples, including in Blue and Ashley. The court denied the existence of an enforceable contract because, inter alia, the alleged agreement to pay £15 million if the claimant raised the company's share price to £8 failed to stipulate the period for achieving this, and there was no objective standard the court could invoke to imply that the obligation would be performed within a reasonable period. And then you also see at footnote 829, we don't need to go to these cases, but if you see at the footnote there's reference to the landmark brickwork case, where a covenant in a contract of employment restricting competition in two named counties and in others to the south of them was too uncertain to be enforced. So the point here is that it's not possible for the court to decide from this agreement when the start date was agreed to be, because it's to be adjusted and revised towards a new date once the progress of the occupancy is achieved. And so there are two levels of uncertainty here. The first is this question about progress. What does it mean? And that's the problem that the claimant sought to solve by using 60%. But it doesn't work. There's no source for that figure. That's now withdrawn. And in any event, that's in the same territory as surrounding, which offended the landmark brickwork case. So the claimant falls back on progress or development. That's how it's put in the now attempted re-amendment of this claim. And that's even more vague, we say, than the 60% argument. But even if you can define progress, then there's a second problem, because the lease doesn't start once progress is achieved. All that happens then is that the parties agree only that they will then revise and adjust the commencement date. So the progress triggers a discussion about setting the new commencement date. It doesn't actually trigger the commencement date. We see that from the letter in paragraph 28C. So even if you could work out what progress meant, you still wouldn't get to a start date. And so the effect of what the parties are doing here is they're saying, we can't go through with this lease now. We're going to put it off for now. And once retail gets busier, then we'll talk. But there's no objective way for you to fix a date. Now, in the pleading, if we go back to the pleading at B, 32B, if you have that on page B282, there's a second attempt, which is just to say, well, there's an alternative. The lease starts when the claimant says it starts. But
what is the practice of the industry? What is the commercial practice in such a case? I'm sure you have these terms all the time.
There's no evidence of any commercial practice, but normally, if the parties agree that they want to have this lease in place, then they'll just agree later. They'll have an agreement later. They'll reach a conclusion later. There's no suggestion that there's any industry standard as to what progress counts as in these circumstances. Very often, people will say, look, we can't do our deal now. Let's put it off and we'll do it in the future. But what that means is that they're not bound to do it in the future. They'll come back, and normally they'll want to do it in the future. But obviously,
but many developers will want their tenants in early, so that they are assured of, particularly the anchor tenant, what they call the anchor tenant. They want to tie the anchor tenant down because they want to do business. They want to have people renting out the premises. So you cannot have things hanging because the tenants want to have some definite time to move in. So you cannot have this. Nobody will deal with you if you keep on doing that. You can't say, I'll tell you when I'm ready. I'll tell you when I'm ready. Nobody will deal with you.
Well, but this is an agreement with Emirates. This is an agreement that was entered into between the claimant and Union Properties, and it's not an industry standard term. They've just said they'll once there's progress on retail rental, then they will agree a further date. They put it off into the future, and so the question is, can you fix a date from that? Or can you fix an objective way of ascertaining a date from that? And the answer to that is no. And the claimant says, well, look, courts are generally reluctant in these circumstances to find that terms of contracts are so uncertain that they don't have any force. And that is true. That's correct. But this is a real legal principle. It exists, it applies, and these cases are modern cases that I'm referring to. And usually the point is that the court wants to give contractual effect to parties' agreements. But here, my argument does give contractual effect to the parties' agreements. The parties intended to put the lease on hold indefinitely, and that had a legal effect on their obligations, on their agreement. That was what they agreed would happen. It would go off. And so there's no way for one of them, just as one of them can't turn around tomorrow and say, well, let's get going, the other one can't do that either. They have to then agree when the lease will start. And the fact that you can't figure out when the lease starts is reflected in the fact that the claimant's case on when the lease starts just is completely shifting and incoherent, as I showed you. So the old pleading, as I've shown you here, was that the commencement date was put back until when 60% of the retail was leased. And so at the hearing, we produced this evidence that it had never got anywhere close to 60%. And so on the claimant's own case, the lease hadn't even started 10 years after it was agreed. The new pleading seems to suggest that it started in November 2012, but that's simply by asserting a claim for a term for which there isn't any evidence and which isn't reflected in the actual letter of agreement that came from Union Properties. It's just been invented. And then I showed you the prayer at the end of the pleading, which said, oh, well, actually, it's going to start, the lease is going to start sometime in the future. The reality of this is there's just no answer to the point. It's not possible, objectively, to determine a date when this lease starts. And so all these points about the claimant can waive this, none of them take the claimant anywhere. I don't even know if that's still run. It was put in the skeleton argument. It was said, oh, well, this is just a condition that the claimant can waive. Alternatively, this is Emirates taking advantage of its own breach. None of that works. This isn't a term which imposes any obligations or any benefits on the parties. It's a term which is amending a term as to when the lease commences. And when the lease commences, that brings benefits and burdens to both parties. And so the whole lease depends on when it starts. It's not something that can be waived. You can't waive the start date. Otherwise, you just don't have a start date. And it's certainly not something that would be for the sole benefit of the claimant. And there were also arguments that Emirates somehow affirmed the contract. Affirmation's got nothing to do with this. Affirmation's about authority or breach being and the contract being affirmed. It's got nothing to do with the situation that we're dealing with. And then there was also an argument that this could be severed somehow, but then you wouldn't have a start date. So there's just no answer to this, and there's really no response to it other than an incredibly dismissive response that somehow Blue and Ashley is not a serious case. It was a High Court case decided only a few years ago. That's what I had to say about uncertainty, and that's the first defence. The final part of what I was going to say then is about this question of illegality and unlawfulness. Hopefully I can get through this, subject to any questions, I can get through this in about 10 minutes. So I'll carry on if you'd like me to.
Yes, please. We'll. I mean, I would like to request for a short break after you have completed your submission, Mr. Montague.
Of course. There's no need for you to request. You can simply direct it, Your Honour.
I'm requesting my coach and co-director, but my judges who are sitting with me, yes. I'm requesting that for your concurrence.
Of course. Of course. Yeah, so I was being glib. I'm sorry, it was a bad joke. All right, unlawfulness. So the final point is that this strata management statement prohibits the use of the units as a bar and restaurant. I don't think I ever showed you that, but I'll show it you very briefly if I may, because it's worth just chasing this through and showing you how it leads to this problem for the defendant, for the claimant, sorry. It's bundle K, tab 2, is where the strata management statement starts. And you'll see it establishes the statement through the on page 2080, the higher body corporate, the lot owners and the occupiers are bound by the provisions and so forth. And if you go down to 2088, you see there item 13, restrictions on lot use. B, a retail unit must only be used and occupied strictly for a retail permitted use. And then if you go down 2109, at the foot of that page at JJ, retail permitted use means the use of a retail unit as is consistent with the operating standards. Without limiting the generality of the above, retail permitted use does not include Roman numeral 2, nightclubs, bars, cafes or restaurants. And as a result, the result of that is that use of bars and restaurants is prohibited by law. You get that from bundle L, tab 3, which is the Strata Title Law, Article 9.6, which you'll find in 2290. Where a strata plan shows expressly or by necessary implication the use for which a lot is designated, the registered owner must not use the lot for another use or permit it to be so used. And then for good measure, down at page 2364, Article 1351A, the owner or occupier of a lot established by a scheme under this law must not use the lot or permit its use for a purpose other than a purpose for which the lot is established as indicated in the relevant registered plan or scheme. Now, Emirates is not responsible for this. I'm sorry.
I'm not too sure of the timing here. Is there a possible question whether these restrictions on use were in force at the time the lease was granted?
Not when the, well, sorry, go on.
In favour of Mr. Bowden that there is a lease as at 2012. Were these restrictions in force then?
The strata management statement was not was finally registered in I think June 2012, so after the lease was originally entered into.
So is that a possible problem? In other words, there is a lease which permits something to be done, and if the lessor then entered into some arrangement which prevented that from being done, it's the lessor who's in trouble and not the lessee.
Potentially, but that doesn't. So there's a number of questions there. Obviously, the lease is a private agreement between parties. The effect of the registration is that it makes those uses prohibited. Now, Emirates was not involved in the registration or the drafting or the agreement of the strata management statement. So Union Properties, according to the claimant, Union Properties said to the claimant, you can go ahead and use this as a restaurant and bar, but then subsequently signed up to a document, the effect of which is that they couldn't use it as a restaurant and bar. And so clearly, you're right, that might have consequences in terms of liability on the lessor, on Union Properties. But what I say is it can't do is get around the black letter of the law. And the law just says the owner or occupier of a lot cannot use it or permit its use for a purpose other than one which is indicated in the plan or the scheme. And so there is, you're right, it might have private law consequences, but this is a piece of legislation which, and it affects other parties as well as Union Properties. It affects the other occupiers of the lots, it affects the other owners of the lots, and across the whole of the plot, which includes both the hotel and Limestone House. So I agree it could have consequences in relation to Union Properties, but I cannot see, and it's not argued, well no it is actually, sorry, it is argued, but it's very hard to see how it could have a private agreement could amend the terms like this. So does that answer the question?
Thank you, yes.
There was a suggestion raised below that Emirates might be stopped from raising this point because it was said other owners of the plots had given permission for the use in this particular case. But it's not explained how that estoppel arose, and certainly in a normal estoppel, the promise would need to be granted by the person against whom the estoppel is advanced, and that would be Union Properties and possibly the other owner, or AUH, it's alleged. But the point here is one of illegality. Can this contract be enforced in circumstances where the use which is required of this property is currently contrary to the law? Now the claimant says, well, this can be resolved at the remedies stage because you can make an order to amend the strata management scheme, but it's not clear who that order would be made against. It can't be made against Emirates in these proceedings. The people who can apply to amend a scheme are the higher body corporate and I think the owners of the lots that are concerned. But it's not obvious, there's certainly no claim, but it's not obvious how that entity could be ordered to amend the SMS, the strata management scheme, on the basis of some statements made by other parties who I believe are no longer, well, Union Properties, for example, is no longer the owner, and I think AUH is no longer the owner either of the hotel. So Zane, for example, is the owner of the units now, and Limestone House. So why is it that Zane should be visited with the consequences of somebody else's statement and lease granted to the claimant? It's not obvious why or how that could be right. And in fact, no claim has been advanced to amend the SMS in the history of this lease and these proceedings. And as I say, we're now 4.5 years into this claim, let alone this lease. So the effect of that, I say, is that the lease is now unlawful, and it has been at least since the SMS was registered. And so the effect of that is frustration of the lease. The only response that is now made to this, as far as I can see from the skeleton argument that was filed most recently, is that the claimant relies on Article 23 of the Real Property Law, which is at I-1694, which says that registered instruments have priority according to when they were registered and not according to when they were executed. So, I say in relation to that, this clearly isn't applying. It's not relevant to this situation. It's dealing with competing interests where two instruments, say two leases over the same piece of land, are involved, and they create incompatible rights. It doesn't have an application in here because in order to be lawful, there must be a strata management statement which permits the use as a bar and restaurant, and the lease cannot serve that function by itself. The lease can't permit itself, and in any event, that argument would require the claimant to establish that the lease was in fact registered prior to the SMS was registered. And as we've seen, according to the registrar, A, the lease was never registered, but B, nothing could be registered according to the registrar until after the strata management plan, which came after the strata management statement. So I say that result is that the lease would be unlawful, even if it could otherwise be enforced. The point can be put in a number of other ways, though, because it can be put in contract as well. So the claimant is obliged to use the unit as a bar and restaurant, and I showed you those clauses which required it to open for business, and it's not able to do so. So it can't perform its fundamental obligations under the contract. So if the lease wasn't frustrated, then there would simply be an anticipatory breach, which would entitle the defendant to terminate, and it gave notice of that in its defence. It also shows that there could be no loss, as I've said, because, as I pointed out, the proposed new case is that the lease commenced in November 2012, and no steps have been taken in the 8 years since to amend the strata management statement. And so actually, the claimant's position would have been that it would have been obliged to pay rent through that whole period, but wouldn't have been able to open its business or run its business. So until that strata management statement is amended, even if it could be amended, that's a process that would take some time. Is it seriously suggested that that's going to happen in circumstances where the lease expires in November 2012? And even if it was, you'd have to take into account the loss over the entire period, which include all the rent that would be immediately, or according to the respondent's own case, the claimant's own case presumably, is now due. So that's the second defence which I advanced and which the judge below accepted as inevitably following from the terms of the SMS and the lease. And another reason why this proposed case, had no real prospect of success, regardless of the position that was taken. So that is all I had to say in relation to the defences. There are a number of other matters which are raised, as I've said. There is what I say is a scandalous allegation made against the Deputy Chief Justice that he was biased. It's never been properly explained what that allegation of bias is, other than that he accepted my submissions, which could never be a proper basis for an allegation of bias. There's no suggestion of any relationship with any of the parties or anything of that nature which would give rise to any suspicion. It is a very serious allegation to make against a sitting judge, and it ought to be given short shrift, and it ought to be dismissed in pretty stark terms. And I noticed that my friend may have felt better of it, given he didn't actually advance that position orally. There's a claim for a witness summons that was advanced below. The judge was clearly right to dismiss that application and not summons a witness to an immediate judgment application. I've never seen that happen in any application of this sort in my entire career. There's either real prospect of success or there isn't. It either has to go to trial or it doesn't. And determining that isn't going to require the cross-examination of Ms. Fernandez. There's this allegation about there ought to be further disclosure.
Hang on a sec. I'm sorry, it is difficult when we end up talking over each other because of delay. My apologies. From Mr. Bowden's commencement of his submissions, where he identified the applications which were the subject of appeal, they did not include anything about that witness summons.
I see.
And I have taken it, unless he says otherwise, that the witness summons is nothing to do with us. I should make it plain. That's my understanding from his opening, where he identified the particular matters he was concerned with.
I agree, sir. It's too late.
Understood. Thank you. There is an application for further disclosure, and I say there's absolutely no basis for that. Clearly, if there's no real prospect now, then the claim can be dismissed without that. It's only if the claim proceeds that there would be any need for further disclosure. The disclosure statement has been given, and the problem with disclosure has been comprehensively addressed in the witness evidence that I took you to, and substantial further investigations have been made, as is traversed in the evidence of Mr. Faddy Brocklehurst in particular, directed at those particular complaints, and nothing subsequently has been found. The harvesting error, as I said, resulted in further disclosure, but that has been done. And that's clearly a discretionary case management decision, and it was a right decision. But and then there are also obviously these fraud allegations, some of which they sought to plead originally, some of which are new now, and those I would suggest, even if the claim is to proceed, should be wholly rejected. Firstly, they obviously depend on the central case that Emirates is bound by the lease, and they don't take the case any further than that. So they have to win on these core points that I've been addressing before you even get there. But even if you do get there, I say there's just no credible basis for asserting a fraud. My friend seemed to suggest that he could get away with asserting fraud without asserting actual dishonesty. But as I read his own authorities and the presentation, it looked like that he produced, that is absolutely not what the authorities say.
It's quite well established when you allege fraud, you need a strong case, you need a lot of evidence to support your allegation. So
and there's just nothing of that sort. So the case would have to be not only that Emirates was bound by the lease, but that it knew that it was bound by the lease, and therefore any argument to the contrary just can't be right. You'd have to infer that, and therefore I can't be sitting here in front of you honestly saying that Emirates is not bound by the lease. It's just a very extreme submission, and it shouldn't have been raised. So I'll leave it there in relation to those points, if I may. There was in the skeleton argument another argument raised about, I think, sorry, not in the skeleton, in fact, in the authorities, about failure to give reasons. But again, that hasn't reared its head, so I will also leave that one there as well. Those were the only matters that I was going to address you on, in addition to the core central allegations, unless you have any further questions for me.
Okay. I don't. We'll take a how long? 20 minutes break. Is that fair? 20 minutes break. Thank you.
Even shorter if you like.
No, I'm thinking of Justice Giles. He's already 10 p.m. in Sydney.
Yes, I see that.
You know, that's.
It's getting towards bedtime, so if we have a 10-minute break.
I know. I'm sorry.
I think Justice Giles would prefer a shorter break.
So let's take a 20 minutes break. So we'll start about what is it? I'm 8:30. Roger is 10:30. Dubai is 4:30. London is what? 1:30. Is it?
Correct.
Okay. Thank you very much. We'll take
Sure, thank you.
Yes.
Yes.
Thank you very
Okay, Mr. Bowden, how long are you going to take? I hope you don't take too long. Well, I hope you just reply to just don't repeat, don't go
Try
into. I feel sorry for Justice Giles. As I said, he's already
I agree.
Ready to go to bed now.
Okay.
Don't feel afraid, Mr. Bowden, but also please don't repeat.
Yes, do repeat. Okay.
Look, my learned friend, he is a marvellous advocate. I have to give it to him. But seriously, when the parties went down there on down to the RORP on the 28th of May, and they signed a lease registration form which said exactly that, and it attached a lease. We all know which lease it is, and it's a lease for 10 years. Seriously, this case, it's going to make a mockery of the law if it finds that was not effective and binding. It has to be, and there's no way that it can't be. So if we just step back from all Mr. Montague-Smith's fine words and look at the real fundamentals of this case, there was an offer made to sell these units subject to the leases. When Emirates replied to that offer, and it's on the 26th of December 2011, they offered to take them subject to the leases. At that stage, they said that they would split the rental in exactly the way that it was done. They said that they would make a single payment, and that was done. They never said, they said that it would be dealt with under 2 MSPAs. And we know all about what happened. There was a draft, the draft has disappeared. It's not enough to say that we have looked here and we have looked there when you have made 5 successive attempts for document production. The first of which contained exactly zero documents were disclosed in the first instance by Emirates. So it's not enough to say we've looked here and we've looked there. It's not enough to say Union Properties, with whom we have a commercial relationship, haven't provided it. When you have not even asked your own lawyers for a copy and somehow say you don't have to. Now that's just wrong. Now, regarding the strata management, so just on the subject of the pleadings are extensive. Each pleading that my learned friend refers to repeats all of the previous pleadings. He simply cherry-picked bits out. Nobody has mentioned novation before today, including my learned friend. If the matter can be cured by amendment, well, it should be. That's not a reason for striking it out. And novation itself does not need to be confined to a single document. And there is, with respect, ample evidence here spread across a number of documents that these parties all agreed. If we look at the offer to sell on the 18th of December and the offer to purchase on the 26th of December 2016, those documents are themselves sufficient to set up the novation. The notice of atonement is clear evidence of a novation, all three parties agreeing. Now, moving on.
Sorry, you said 2016, did you?
Sorry, sir?
You talked about an offer and an acceptance in.
Yes.
Or
would you like the page references to those, sir?
This is not reply. A, this is not reply. B, this is a brand new additional further case that's being advanced that wasn't advanced. I can deal with it. There was no offer, there was no acceptance of an offer, and that was accepted by my own friend in his skeleton argument. There's going to have to be a response to this reply, I'm afraid, if we're going to go down this route.
That's simply untrue.
I just want to understand it to be, I beg pardon, Mr. Montague, I want to understand it to begin with. You are right, there has been no mention of these things, and I just want to understand what is being attempted.
Sorry, sir, the offer letter dated the 18th of December 2011, we were looking at it this morning.
2016, is that a mistake?
No, sorry, sir. 18 December 2011.
Right, okay.
My apologies if there was any misunderstanding. And the reply from Emirates, also in the bundle, sir, at dated 26 December 2011, just 1 week later, sir, is what I was referring to. I apologise for that. And that reference, sir, is D799. And I'm particularly referring to paras 4 and 6. 6 brackets D, indeed. A further reference, sir, you asked about the Registrar of Companies application and asking that we can establish that Mr. Naki Al-Khalili, who made the application, sir, was an officer. The trade licence, sir, is under tab E11 at page 1574. Regarding the strata management statement, sir, Your Honour is quite correct in your observation to my learned friend that the lease in 2011 does predate the drafting of the strata management statement by a long way. But not only that, sir, the parties who drafted the strata management statement were the owner of the Ritz-Carlton, that's NC-T&H, and Union Properties. And at NAM 3, sir, and that's reference D754, it's set out there that Mr. Munib, the general manager of the company, sir, of the Ritz-Carlton, the owners of the Ritz-Carlton, gave permission specifically for this lease to go ahead and for there to be a liquor license there, sir. So, yes, the SMS can be amended. It should be amended. But in the absence from a decision from this court, sir, it would be pointless for us to seek to amend that license, and it would be it's just absurd, sir, to say that we should do this. And if there are any consequences flowing from it, it would be against those, sir, who drafted the SMS when there was indeed by that stage a registered lease, because the lease was registered on 28 May and the SMS was registered on the 2nd of July. So by the time the SMS came to be, strata management statement came to be promulgated, sir, there was, not only did the lease had been drafted 2 years earlier, or a year earlier, sorry, but the lease had been registered some months earlier. And that, with respect, sir, disposes of the argument. Regarding the SPA, there is no term of the SPA which would override the terms of the MSPA, the ones that we have seen. So that point doesn't matter, sir. And we've looked at it in detail this morning, but it's a myopic concentration on 3 words in that SPA rather than the entirety, sir. I've dealt with the MSPA there, sir. Now, on the subject of assumptions, sir, my learned friends seem to be in a little bit of difficulty on the subject of, well, what happened? What was Emirates thinking when they went to the Registrar of Real Property and registered this lease? Because they had to have been thinking something, sir. And all that my learned friend can really say about this is that Ms. Fernandez must have believed that the lease was transferred, and acting on that assumption, she signed it. Now, that's what I understood my learned friend to say, that there was a mistaken assumption. There's a number of problems with that. The first problem is that there's simply no evidence other than my learned friends say so that ever occurred. And with respect, it can't have occurred. But even if it did, sir, and my learned friend mentioned Brown and Root technology, and I apologise, I have sent through a list I have tagged many documents in the bundle, sir, and I've sent through to the registrar a list of the colour tags. So if we look for Brown and Root technology, sir, the quotation is this: it would be wrong to allow technology and B&R to depart from the common assumption which they themselves had agendaed. For example, by allowing B&R to raise the absence of registration as a defence to a direct claim for rent by Sun Alliance. So that is the point, sir, in equity. If you are responsible for the assumption which has arisen, and Emirates clearly were, because they were the ones who had been collecting the rent prior to the registration, well, they are bound by the consequences of that assumption, sir. That is what the law says. So if Emirates didn't want this lease, sir, they should have said right at the beginning, the moment they found out about it, that we don't recognise this lease. But they didn't. They collected the rent. We've gone through it. They fought for the rent. My learned friend says, "Oh, that was an assumption." Well, it was an assumption. Yes, sir.
Just
please
clarify something. When you say they were getting the rent, are you referring to the documents you took us to that showed, yes, based on Mr. Montague Smith's view, just an apportionment of the rent? That's what you're referring to?
Yes, sir. Yes, sir.
There was no actual payment of rent in the sense of money passing from Vegie Bar to Emirates at any relevant time. Is that right?
Well, that is correct, sir, yes. But right. What is the effect of that? Does it matter if they pay it direct to Emirates or if they pay it to Union Properties and Emirates claim it from Union Properties? Is there a significant difference? And that's got to be the question. And the answer in my submission has got to be no. The money, the pot, was sitting with Union Properties. Emirates collected from that pot. Doesn't matter if they collected it direct from if they collected it via Union Properties or direct from the claimant. And the answer, sir, has got to be no. I'm unaware of any legal distinction, and I don't see that there can be any. They acted as a landlord, and then, sir, they turned around and consented to the registration of it, and banked the cheques, and banked the cash, sir. So really, sir, if there was any assumptions, they were set up by Emirates. And now the next point is this, sir. If it might be possible, if I can, to just run you very quickly through the law, which is actually through the law of real property. And if I go to the tabs, and if I pick, if I've started my presentation, if you could just quickly push follow presentation, and then we go I'll just change colour to grey, and then I will, if it's possible, just very quickly take you through the relevant pages. And what I have done, sir, I've used the tabs function, and I have tabbed in grey down the registrar of real the DIFC law of real property, and have set out the sections.
Where's that? Where's that?
This is on, if you've pushed present, sir, or even if you haven't, it's over on tab I, or section I, and then there's only one tab in it. It's the DIFC law of real property.
Yes.
Okay. And then on the right hand side of your screen, you've got the tags. Do you see that? If you click, and it will open a series of tags in grey. Case notes, page notes. Do you see those?
No, we have not received your note yet. Maybe you have not shared it with us in the proper basis.
Yes, it should be widely shared. Oh, you have not received those notes. I apologise. There are, okay, I'll send a note through to the registrar.
Just tell us what the sections are.
Yes. Okay. Working down through the law of real property. 14. The registrar must establish and keep a proper register. And then we go on to 15, sirs, the contents of the register and the folios of the register. And this is the law that we were talking about before. The register may be kept, this is 15.2. The register may be kept in any form, documentary or otherwise, the registrar considers appropriate. So it is up to the registrar to decide the form of the register. However, sir, it is not up to the registrar to determine whether or not a particular document has been registered. That is a matter of law. Sorry, excuse me. And the registrar at 15.3, sir, the registrar may change the form in which the register is kept. The register, 16, sir, the registrar must record in the register every folio, every instrument registered, every instrument lodged. And then, sir, I'll just move quickly through it. The registrar's duty to register instruments. So, and this applies to the lease registration form. Now, I heard it said, I think you put up this proposition for consideration, Mr. Chief Justice, that the document may not have been properly lodged in registrable form. With respect, the registrar's signature on that document is evidence and conclusive proof that it was in registrable form, because that is what he is certifying when he signs it. So, under Article 19 of the law, if a person lodges for registration an instrument that affects real property and that is in registrable form, the registrar must register it. And indeed, that is what occurred, albeit with the spreadsheets which were kept then by DIFC Registry Services. There is no other available explanation. And then, sir, at Article 21, the order of registration of instruments, they are registered, instruments that are in registrable form must be registered in the order which they are lodged for registration. So even if my learned friend was right and it wasn't registered for some reason, if it was presented in registrable form, it must go in priority to anything else which came after it, including, of course, the strata management statement. The priority, again, under 23, registered instruments have priority according to when they were registered, not according to when they were executed. It's the lease that comes before the SMS. And then 25, conclusive evidence of information in register. the information about a registered instrument recorded in the register is conclusive evidence of the registration of the instrument. So if those spreadsheets that we were looking at, kept the ones with the yellow band, kept by DIFC Registry Services, are the register, that is conclusive evidence that there was a lease and that those were the terms of it. And then I'm going to just finish there, sir, with paragraph 29, clause 29, sorry. Subject to this law, the registration of a person as an owner of interest in real property is conclusive evidence that the person is the owner of that interest and that the person's title to that interest is indefeasible. And so, sir, if that lease was registered on 28 May 2012, which I say it must be, that is, as the learned Chief Justice said, that is the killer point. That creates the mandamus, and that ends this case right here. And it doesn't matter what else is said about pleadings, because we pleaded the registration. It doesn't matter what else is said about uncertainty or anything else. It was registered as at that date. On the subject of uncertainty, it is a fact that at the time that the 15 March agreement was entered into to put the lease on hold, Union Properties were acting as the agents for Emirates MBD. And there, if you wish the page, do you wish the page reference for that, sir? Now, sorry, I lost my place. I'd wish to go to Brown and Root Technology. Oh, sorry, I did do that. My apologies, I did that.
Give us that reference.
Yeah, thank you. That's dealing with that. Oh, yes, sorry, the reference there to the fact that as at March 15, 2012, Union Properties were acting as the agent for Emirates as at NAM 15, and the page reference is D2794. Yeah, and that is an email from Melanie Fernandez. Next, sir. On the issue, I've dealt with that, sorry, sir, I've dealt with that. Just the issue of the 60%, sir, that is evidence which came from Emirates. That was an internal email dated the, sorry, my apologies, 23rd of April 2013. So, and that is at page reference D1091. There was a series of emails internal within Emirates asking, talking about this, and it was Miss Fernandez who said that, oh, it's yes, I do know about this, and this lease was on hold, right, pending, and she said pending 60% leasing in the surrounding area. And so all that was done, sir, it was an untidy pleading. And I do accept some of my learned friend's criticisms about these pleadings. Mainly my learned friend's criticisms are that he could have done a better job, something that I undoubtedly agree with. But There was a looseness in the pleading there, and it allowed my learned friend to, if you like, opportunistically seize on it and say that that was in fact the case. It really, sir, it wasn't pleading, it was evidence. And it was simply the evidence that Emirates knew about the agreement to put the lease on hold. And how long that on hold lasted for, sir, the proper answer, I think, is to go to the case of, and if I can just take you there, the proper reference to, sir, is to the case of, sorry, the authorities. What's the colour of the authorities? Oh dear, green. My apologies. The proper reference, sir, is the case of open work in our bundle. And if we are still sharing, I'll take you there now.
What was the name of the case again? Open
work, sir. J9. And just quoting in that case, sir, Astor Management, and it refers to a case called Astor Management, and the role of the court in a commercial dispute is to give legal effect to what the parties have agreed, not to throw its hands in the air and refuse to do so because the parties have not made its task easy. To hold that a clause is too uncertain to be enforceable is a last resort, or as Lord Denning MR once put it, a counsel of despair. And then further down, sir, at paragraph 28 of that, in Petromac v Petroleo Brasilio, that's at page reference J1857, to decide that a clause has no legal content, to use Lord Ackner's phrase in Walford and Miles, would be for the law to deliberately defeat the expectations of honest men. And really, with respect, you know, that's what's going on here. It's a fact, I think it's one that judicial notice can be taken of, that developments in Dubai, they run over time. Frequently they do, and they are the cause of a great deal of disputes, keep lawyers busy. But what has clearly happened here, and it's in Mr. Al-Khalili's evidence, is that he was keeping an eye on it, and he did go back to Emirates in November 2012, and we saw the references at NAM, I think 76 this morning, either side of the, what I say are the fraudulent attempts with the spreadsheets with the hidden rows. Between those two, there is a lengthy reference at NAM 76 of Mr. Naki Al-Khalili attempting to engage over a period of months, indeed years, with Emirates NBD to try to get them to come to the party and hand over his lease. And if it's asked, why did he not actually pursue this through the courts at an earlier time than 2015? Well, he kept working all through 2015, and indeed the RORP speaks in his letter about the fact that there was an attempt by somebody, and Mr. Al-Khalili says that it wasn't him, to register a further lease registration form in 2015. Mr. Al-Khalili says, that was not me, it's not my writing, the details are wrong, I didn't do it. But the point being that right up until that time, he was trying to get into the lease, and only then did he take action. And why has it taken so long? Well, we've had 5 failed attempts at document production by Emirates NBD. Page 10 and page 11 of the second day of the hearing in the transcript section, C2, page 10 and 11 internal pages, do set out Mr. Montague Smith's explanation for what happened. And it is the fact that right up until the eve of the trial, documents were trickling in, which should have been there months and months ago. And somehow this is all turned around to being a delay by the claimant, and that can't follow. With that, I realise, sir, it's been a long day for everybody. I don't want to repeat myself any more than I have already done so. Quite frankly, sirs, we believe that we have a very strong case based on the apparent intentions of the parties, based on what the MSPA would say if there was one, based on the fact that these parties, they did collect rent, and that was actively pursued. Any assumptions or misunderstandings which have been engendered through that process actually go against Emirates. And we say, sir, that the registration of this lease is in fact decisive. When they signed and stamped that lease registration form, that was effectively the entry into the register, because if it's in registrable form, it must be registered, and it was. Thank you.
Thank you very much. Thank you very much. Any questions from Judge Roger?
Mr. Burton was going
Ali?
on equitable fraud.
Oh, yes, sir. Yes, I did, and I've emailed that through to Maitha. And if I just go to that, yes, I found at least one authority that I had on hand, and I do apologise that I didn't deal with that matter as well as I should have. And I did set out the case of Vegie v. the winning combination, which is, it's actually from the Court of the Queen's Bench of Manitoba, but it has a lengthy review of the authorities relating to equitable fraud. And I particularly, sir, mentioned the paragraphs of 33, 36, 56, and 58.
Where do I find it? Is it in the...
It should be in an... I will load it straight after this, sir. I didn't want to interrupt my learned friend's page numbering or any references, but I'll load it straight after this, and I've emailed it to the registry at 2 o'clock this afternoon.
I have received it, Justice Roger, yes. I have it. In my email, yes.
Yeah, if I can, sir, I'll load it.
Again, please.
It's Vitacea, Vitacea, V, the winning combination.
I appreciate I'm a minor player here, but is there any chance that I could have a copy as well?
I sent it. Sorry, I sent it to James Baldwin. I tried to send it to you, Tom, but I'm sorry, my email bounced back. I apologise.
So, and the paragraphs you prefer to are 33, 36, 56, and 58, are they?
I am indeed. That's right, sir. And it also referenced to.
Hang on. What is the proposition you say I get from looking at them? Just in one sentence.
At paragraph 33, sir, it gives an excellent example of how an equitable fraud works. And that is, sir,
look.
Yes.
What is the proposition?
The proposition is that if Emirates sold the freehold to Zane, knowing that they had the benefit of the lease, it is unconscionable to allow them to keep the proceeds of it. Or, in this case, it would be wrong not to allow Vegie Bar to claim damages for that action. That is a proposition, sir. And it does not matter whether Zane were a bona fide purchaser for fair value or not.
Yes. Well, now, I think that Mr.